All right, good morning, ladies and gentlemen. My name is Judge Law, and is everyone present?
Good morning, Your Honor.
Mr. Jordan,
Good
who's
morning.
my litigation manager?
It's going
Is
to
it
be
Melissa?
Yes, it's going to be Miss Grace this morning, Your Honor.
Okay. Good
I'm
morning.
on the way
Good
down,
morning, Ms.
Judge. I'm on the
Maldonado.
way down.
Okay, I can't, let me see what's going on. Okay, there's issue with the speaker here. Hello, can you hear me?
Judge.
We can hear you, Your Honor.
Okay, a little glitch with the speaker. Ms. Champion, you're hosting? And Ms.
So it's going to be Miss Grace. She's on her way down to the courtroom now.
Okay, thank you. Let me go ahead and begin the calendar then. Good morning, ladies and gentlemen. My name is Judge Law, and this is going to be the Fulton County State All-Purpose Calendar. This is a list of misdemeanor cases in which individuals have already been accused of one or more misdemeanor offenses. Bonds have already been set. Most of these cases have already had an initial appearance. And we're going to revisit the status of the case to see whether we're going to entertain a plea hearing or whether the cases are going to be arraigned and set for trial, or whether there are any other matters to address, such as bond amendments or anything that the defense or prosecutions would like to address in these particular cases. If you are a defendant accused of one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you choose to say during the course of this virtual Zoom proceedings, your statements can and will be used against you. This entire proceeding is being recorded as well as live streamed. So please be mindful of what you say and let your attorney speak on your behalf. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you from the public defender's office, or you may qualify for a conflict defense counsel. If, however, you have a private counsel, then that will be your attorney. And so I have in courtroom 2, an attorney standing next to the defendant. Good morning, sir.
Good morning, Your Honor.
Yes. And who is the defendant?
Yes, Your Honor. This is Nathan Lindsay. He is also booked as Narraton Brooks. And so under the name Narraton Brooks, he's positions 5, 6, and 7. And under the name Nathan Lindsay, he's positions 13, 14, 15, and 16.
So same individual has the name Brooks for positions 5, 6, and 7. And the same individual has the name Lindsay on 4 more cases.
Your Honor, I believe his legal name is Nathan Lindsay. His legal name is Narraton Brooks. I don't know where the confusion came from. But in Odyssey, it's the jailing's all under the same individual, but for whatever reason, it's 2 different names on the calendar.
Let's see now. Who's the prosecutor?
These are my cases, Your Honor.
All right, all 7 of them. Excellent. Mr. Walker, how's the state planning to address this individual?
We are pursuing all the charges on all the cases, Your Honor. Are you asking specifically about his name? You mean different?
No, I'm just wondering, are you, for positions 5, 6, and 7, is he being addressed as State of Georgia versus Narraton Brooks,
That
also known as Nathan Lindsay?
That is correct, Your Honor. I believe
All
he's
right.
booked into the jail under 2 different names and 2 different aliases.
All right. And who's the counsel? I'm sorry, with your mask on, you please identify.
Not a problem, Your Honor. Angelo Dotis with the Public Defender's Office.
Mr. Doty, okay, correct?
Dodis.
Dotis, sorry.
That's okay.
All right, Mr. Dotis, these are 7 cases and you represent Mr. Brooks, AKA Mr. Lindsay, in all 7 of them.
Yes, sir.
And how will we be proceeding?
For positions 5, 6, and 7, we'll be waiving arraignment and entering a not guilty plea. For positions 13, we'll be waiving arraignment and pleading not guilty. We request to address bond.
Mhm.
And for positions 14, 15, and 16, we would request to set aside the bench warrant, if Your Honor will hear that.
All right, let's first address positions 14, 15. Okay, so first of all, you are filing the waiver arraignment for positions 5, 6, and 7, correct?
Yes, Your Honor, and I'll have that, the court manager as soon as I get out of the courtroom.
All right, so Mr. Brooks, also known as Nathan Lindsay, for the 3 of your cases in positions 5, 6, and 7, your attorney is filing a waiver of arraignment and entering a not guilty plea on your behalf. So these 3 cases will be further noticed for a jail jury trial. Miss Grace, sorry about the little thing. Okay. And I'm keeping track of where I am so we can get you. Excuse me for that interruption. And for positions 14, 15, and 16, Mr. Walker, those are your cases as well?
That is correct, Your Honor.
All right. All right, Mr. Dotis, ready to hear your request to set aside the bench warrants for positions 14, 15, and 16. Go ahead.
Yes, Your Honor. Mr. Lindsay or Mr. Brooks on December 15th, 2022 had an FTA at, I believe, a final plea hearing. After speaking with Mr. Lindsay and confirming with his mother, Miss Alicia Stevens, who I don't see on Zoom. She did say she was going to try to be on Zoom, so I'll look out for her. Confirmed that Mr. Lindsay was in the hospital with a stomach ulcer. He attempted to hop on Zoom to let the court know, but the presiding judge told him to come to court anyway, or there would be a failure to appear. Mr. Lindsay has a stable address. He's clear that he has to keep that updated with the court and knows that this won't be an issue moving forward. So for these reasons, we would ask for the 3 FTAs, which would have been all handled on December 15th, to be set aside.
And do you have documentation that he was inpatient on December 15th?
Your Honor, I did not have enough time to look into the paperwork. I'm taking my client and his mother at their word.
Was she supposed to come to courtroom G33 this morning?
Your Honor, she was going to try to hop on Zoom. She's currently in the hospital with Mr. Brooks's uncle, her brother. He's having heart issues, and she said she was going to do her best to step aside and hop on Zoom. I sent the link, but
What's her name?
her name is Alicia Stevens.
Alicia Stevens, are you on Zoom? All right, she's not here. All right, so I don't have any documentation of Mr. Lindsay or Mr. Brooks being an inpatient, being an inpatient at a hospital or a medical facility on December 15th, and his witness who wants to corroborate that information is not present. So I can't grant any set-asides at the present time. Unless you have something else for me to address.
Your Honor, could we reset this to next Thursday then, so I have time to look for that paperwork?
Okay, position 14, 15, and 16 are going to be reset to Thursday, and that's going to be February 23rd.
And I would just request that counsel sends it if he's able to obtain such paperwork.
Yep, go ahead and email or send that to Mr. Walker so he can also address it. If he is convinced, he may agree to the set aside, and y'all can take care of that by just submitting a proposed order.
Okay.
Understood.
All right. As now we go back to position number 13.
Yes, Your Honor. For position 13, we will be waiving arraignment and entering a plea of not guilty. We would request to address the bond.
All right. So on position 13, this is State of Georgia versus Nathan Lindsay, also known as Navratun Brooks, 23 CR 00831F. Mr. Lindsay was accused of loitering and prowling, willful obstruction of an officer, and pedestrian and roadway on February 7th, 2023. All right, the defendant has been advised of his right to remain silent and he has a right to counsel. So presently, if I'm looking at his, excuse me, let me go ahead and pull up the correct. He is presently here on an $8,000 bond, which includes his FTA. And these charges carry on the pedestrian roadway is 1,000. The loitering or prowling is 1,500. And I don't see, oh, and the willful obstruction is 2,500. So that's 2, 3, 4, 5, 5K. Presently, is that your math, Mr. Doris?
Yes, Your Honor, that's our math as well.
Okay. I'm waiting, sir.
Would you want to
What's
hear?
your motion to amend bond?
Your Honor, we're requesting, as Your Honor stated, his bond on these charges is currently totals $5,000. Mr. Brooks cannot afford that, so we would, after speaking with his mother, Ms. Stevens, we would request a $1,000 bond, good bond on each count. I've been told that Ms. Stevens could afford something a little bit lower on closer to that.
Okay, Mr. Walker?
Briefly, Your Honor, the state is opposing the reduction in bond for several reasons. Obviously, the defendant has numerous cases on today's calendar under 2 different names. 3 of the positions are FTA, so he is likely not to reappear. Just to briefly go over his criminal history, I see a robbery conviction in 2009. I see a burglary conviction in 2014. I see false name 2018 out of Clayton County, and then just looking at the Jilling screen, he's currently wanted out of 3 different counties. So just to give you a little bit of background information on this case, him and 2 other co-defendants were looking in vehicles. Upon being stopped by the officer, a handgun was removed from their vehicle, a considerable amount of drugs, and a scale. His 2 co-defendants' cases are in Superior Court. His case is with us in State Court, but based upon him having several FTAs, multiple aliases, being wanted out of several different counties currently, we're not in a position where we would consent to the reduction in bond. We believe that the bond is appropriate as said, whereas that remains.
Okay. Mr. Dotis, do you have a counter?
Yes, Your Honor. Mr. Lindsay's 32 years old. He spent the past 10 days on a bond that he cannot afford. He's a lifetime resident of the state of Georgia and a lifetime Atlanta resident. I have a good address for him, and I've verified that with his mother, who I also have good contact for. I'm still looking to see if she is able to hop on Zoom. I'm not seeing her. Mr. Lindsay has one 12-year-old son that he provides financial support with, and he's currently working for Gibson Landscaping, where he can return. As we stated previously, the 3 FTAs were all from the same day, same incident, and Mr. Lindsay did have a valid reason. It wasn't an intentional disregard of avoiding the court, and we're going to do our best to provide proof of that. He's also clear that he has colds in foreign counties that he needs to deal with. And so he's hoping that if he posts bond here, that he can make progress in those other counties to deal with that. For these reasons, we're just requesting the 5,000 bonds become a 3,000 bond split, 1,000 on each charge.
All right. For the reasons articulated by the state, the court is really concerned that Mr. Narraton Brooks or Mr. Lindsay not only has multiple open cases, but apparently was well aware of the court proceeding in December 15. And since December 15 until February 7, has never taken any affirmative steps to set aside the bench warrant or to address the matter until he was arrested on February 7. So I am not completely convinced that Mr. Brooks or Mr. Lindsay would have taken any affirmative action to appear in court on his own volition. The request for the bond modification is denied. His next court date is February 23rd to address positions 14, 15, and 16. If the state is persuaded that Mr. Narleton or Mr. Lindsay was otherwise was hospitalized on December 15 and unable to attend court, then it's up to the state to decide whether they want to enter into a consent request to set aside the bench warrants. Thank you.
I understood. Thank you, Your Honor.
Position 9, Freeman.
Thank you, dear. And that document that you have. That one. Yeah. Do you need it? Oh, thank you, dear. Okay. And I will be right with you. Just give me 1 minute, please. Thank you.
Lindsay. Not from the Amen. Oh. Hey.
Thank you. I apologize for that. I was just trying to get my litigation manager caught up. Okay, I'm sorry, Mr. Dotis. So we have position 9 now.
Yes, Your Honor, and we will be waiving arraignment for Mr. Freeman and entering a plea of not guilty.
All right. So this is Kenneth Freeman, 23 CR 0000715B. Mr. Freeman is accused of simple battery, domestic violence, and battery domestic violence from October 11th, 2022. Mr. Freeman, you've been advised of your right to remain silent. Your attorney is Mr. Dotis, who will be filing a waiver of arraignment and entering a not guilty plea on your behalf. This case will be further notice for jail jury. Anything else to address in this case, Mr. Dotis?
Not today, Your Honor.
All right, thank you. Next case, please.
Position 1 on the add-on,
Position 1 on the add-on.
Mr. Copeland.
This is State versus Dontarius Coakley, 20 CR 004-147A. Mr. Coakley, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you this morning is going to be, who is representing Mr. Coakley?
I am, Your Honor.
All right, Mr. Dotis, all right. And this person who appeared on Zoom, K51, Ms. Champion, if you could mute that panel, please. Thank you. All right. Yes, Mr. Dotis, position 1 on the add-on. How are you proceeding?
Yes, Your Honor. We'll be waiving Mr. Coakley's arraignment and pleading not
sorry.
guilty.
You did tell me that. Sorry about that. Yeah. But this is going to be a waiver of arraignment. Anything else to address?
Not today, Your Honor.
All right. This case is going to be reset for jail jury. Mr. Coakley, your attorney has filed a not guilty plea on your behalf and waived arraignment. So this case will be reset for a jail jury calendar. Thank you. For North, do you have someone else to address?
No,
Yes.
Judge Law.
Yes,
We're gonna go ahead on courtroom 2. This is gonna be position 12. Mr.
Okay.
Amon Lindsay.
sorry for North, Deputy Francois has just trumped you, so let's move on to position number 4. Was it 4, Francois?
Yes,
All right, thank you.
Oh,
I'm sorry, position 12, Amon Lindsay.
12, okay. This is Amin Hassan Lindsay, case number 23, CR 0000703F. Mr. Lindsay has been accused of criminal trespass from February 2nd, 2023. Mr. Lindsay, you've been advised of your right to remain silent, and your attorney is Mr. Dodas. Mr. Dodas, you're filing a waiver of arraignment. Would that be correct?
yes, Your Honor.
All right. So, Mr. Lindsay, your case is going to be reset for a jail jury upon your entry of a not guilty plea. Meanwhile, we're going to address the request for a bond in your case. So, Mr. Dodas.
Your Honor, my client has a question. If I could have 1 second to address it.
All right, just mute your screen then if you want to confer.
Thank Your Honor, after thinking it over, my client would like to go forward with a negotiated plea. If the state is agreeable to that.
I'm assuming that the state would have to draft the plea paperwork and send it to you for a signature and so forth, or have you got the documents already?
I have the documents here, Your Honor, and I can fill them out and scan them over as soon as possible.
All right, so position number 12 is, we're going to hold on that pending a plea hearing. And so Francois, we're going to hold on position 12, Mr. Lindsay. Can I go to 4 North, dear?
Yes, Judge.
Thank you. 4 North, who do we have?
Position number 2 on the add-on, Mr. House.
Thank you. This is State versus Quamarius Detarius Hosch, Hosch, 22 CR 0070538. Mr. Hosch was accused of possession of a pistol or revolver by a person under the age of 18. Is he still under the age of 18 or no? Still under the age of 18?
No, Your Honor, this is going to be a not guilty today. It was put off for me to consult further with his parents. And this does not appear on his booking sheet. At this time, we're going to plead not guilty. Bond is moot because it's not on his booking sheet. And we would ask for the notice of trial.
All right. Mr. Hosch, you have a right to remain silent. Anything you say about your facts of your case, your statements can and will be used against you. You have a right to an attorney, and you're represented by Mr. Michael McLean. Do you see him on the other screen?
Yes, ma'am.
Right. So your attorney is going to be filing a document indicating that you're pleading not guilty, and your case is going to be reset for a jail jury trial. All right?
Thank you, Your Honor.
I didn't hear the court date.
I don't have a
There's no
trial
court
date.
yet.
Thank you. All right, courtroom 2, who's next?
Position 23 and 24, Mr. Parks.
This is going to be a negotiated plea,
That is correct, Your Honor.
and this is going to be a negotiated plea on position 23. And if the plea hearing is completed, then the state's going to null cross position 24.
Yes.
Okay, Mr. Sampson Parks, you've been advised of your right to remain silent. Your attorney is Mr. Michael McLean. We are going to address 2 cases this morning, 22 CR 007602J, in which you are accused of theft by shoplifting from December 26, 2021. And the second case was a bench warrant, 23 FTA 000115. All right, let's move forward. Mr. Parks, this is going to be a negotiated plea. May I place you under oath? Put your right hand up. Mr. Parks, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Thank you. Ms. Lewis, good morning.
Good morning, Your Honor.
And what is the plea recommendation for Mr. Parks?
The state's offer is 12 months to serve 12 days, credit for time served 6 days with the balance probated, a $500 fine, an anti-theft course, and to stay away from the location.
Can you give me the location, please?
Yes, ma'am. 6149 Old National Highway, which is the Walmart at that location.
The Walmart, 6149 National Highway. Got it. Mr. McLean, does your client agree to these terms and do you stipulate to the factual basis, venue, and ID?
We do stipulate to all three, and he does agree to those terms. He asked the court to accept his negotiated plea of guilty.
All right. Mr. Parks, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you or inducing you to enter into a plea today?
No.
I'm sorry, I didn't understand that response. Is anyone forcing you or inducing you?
No, ma'am.
And has it been explained to you that if you enter a guilty plea today, you would have to give up your constitutional right to have a trial before a judge or a jury in the future? You will not be able to go back to court, confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you entering this plea willingly, knowingly, and voluntarily?
Ma'am.
Are you entering a guilty plea willingly, knowingly, and voluntarily?
She's saying, do you know what you're doing? That's what she's saying.
Do you know what you're doing?
Yes, ma'am.
Okay. All right, Mr. McLean, I'll go with that line. How do you plead to one count of theft by shoplifting?
How do you plead the one count? I'm guilty.
Your sentence is 12 months to serve 12 days, credit for time served 6 days. If you have no other cases holding you at the jail, your jail time is complete and you should be released within 24 hours. Once released, you will report to probation. You'll report to probation next Thursday at 132 Mitchell Street, where you will speak to your probation officer. You will be on probation to pay a $500 fine and complete an anti-theft course. You will also report to probation every month until the fine is paid off and the course is completed. Once you've done these two conditions, your probation will be non-reporting. At all times, you are to stay away 200 yards away from the Walmart at 6149 Old National Highway. Do you understand, sir?
Yes, ma'am.
All right. Anything else, Mr. McLean?
Your Honor, considering the economy, the nation's coming out of COVID, the emergency nationally is still declared until May. I wondered if the court could give him a break financially on the fees.
I'm going to waive his probation fees for February, March, and April.
Thank you.
Thank you. Next case, please.
Position 1, 2, 3, and 4. Mr. Andrews. When we get those.
Sorry about that. Position of Fulton County 4 North. Who do we have, please?
Mr. Andrews.
Mr. Andrews. Okay, and is that? And I'm so sorry, Miss Lewis, are you still there? You will send the null cross for position 24.
Yes, Your Honor.
Okay, please email that to Miss Graves. Okay.
Yes, Your Honor.
Mr. Andrews is
Position
position 1 and 2 on the main calendar.
3 and
1,
4.
2, 3, 4. Okay, so position 3 and 4 were the bench warrants, and position 1 and 2 were the accused cases.
That's correct, Your Honor.
All right. Mr. Bryce Andrews, your cases are, there are 2 of them, as I've just mentioned, and the other 2 being bench warrants for failure to appear. Case number 22 CR 002-009F and 22 CR 002010F are both cases in which you've been accused of false report of a crime. The first case is from September 21st, 2021. The second one is September 27th, 2021. The other two cases relate to your failure to appear with regards to your accused cases. Now, you have been advised, no, you're not. You have a right to remain silent about the facts of these 4 cases. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Dotis. Do you see him on the screen at courtroom 2? He's waving at you. Excellent. Okay. All right, Mr. Dotis, you want to set aside positions 3 and 4, and you're filing a waiver of arraignment for 1 and 2. Is that correct?
Yes, Your Honor, that's correct.
All right. So, Mr. Andrews, with regards to the false report of a crime, both these cases, your attorney is going to enter a plea of not guilty, and both these cases are going to be reset for a jail jury calendar. Do you understand, sir? Mr. Andrews, do you understand?
Yes, ma'am.
Okay, that's all I needed to hear, to make sure you understand. Okay, so let's address the bench warrants right now. Go ahead, Mr. Dotis.
Yes, Your Honor. On November 21st of 2022, Mr. Andrews had an FTA for his plea or arraignment calendar hearing. As soon as he learned about the, as soon as he learned that about the court hearing, he called Fulton and was told that any future notices would come in the mail and he'd be able to reschedule that. He didn't realize that he had an old address, which is the 105 Helm Drive address in the court system, which is why he received a return to sender on December 21st of 2022. I've been very clear with Mr. Andrews that if he's given a second opportunity, he needs to keep his address updated with the court. It's his responsibility alone to do that. I do have a good address that I'm more than happy to put in the chat in Norcross, Georgia. I've confirmed this address with his mother, Marie Andrews. She's working and unable to be on the Zoom, but I did confirm that it's a good address and different. Mr. Andrews currently has a job that he's hoping he can return to as a cook at Sparky's in Norcross and Motzi's Sports and Grill to help provide for his 18-month-old daughter, who he's financially responsible for. So he's doing his best to have these FTAs set aside in order to be a productive part of his family and be a part of his defense from the outside.
Okay.
This is my question.
Yeah, Mr. Walker, before we do that, pre-trial, I'm just looking for my pre-trial officer on the Zoom screen. Do I have a pre-trial officer? No?
I don't
Okay.
think pretrial is on today, Your Honor.
No problem. Mr. Walker, then you're it.
Yeah, I have the history. He does have a 2021 conviction for hindering another making a 911 call out of Cobb County. That looks like the only conviction that I'm showing. Just to give you a brief background on both of these cases, on 9/24/21, the defendant went into his local police station and filed a report for another individual stealing his Glock 9mm. He eventually admitted to the officer that he made the report to that he fabricated the story for whatever reason. 3 short days later, he filed another report filing the same gun stolen yet again. Obviously, that officer was able to see the report that was filed 3 days previously, hence the second charge. The state does have concerns on both of these cases because the defendant was granted a signature bond on both matters. I understand that the defendant is saying that he had a not up-to-date address on file, but as the court is aware, it's the defendant's responsibility to update the court and the clerk with any change of address. He was already given a signature bond. And considering that both of these cases are crimes of moral turpitude and he has the propensity not to be honest, the state is asking that the bond remain as set, and it goes back to Judge Richardson, who is the court or the judge who issued the bench warrant. We ask that any further determinations on bond are made by Judge Richardson.
All right. Do you know if he's had any arrests since after September of 2021, other than the Cobb County conviction?
Other than the Cobb County conviction, I do not believe so.
Okay. Mr. Dotis, I'm going to grant the motion to set aside the bench warrants in positions 3 and 4, but I'm going to amend the bonds in positions 1 and 2.
Yes,
Ready?
Your Honor.
All right. On position 1 and 2, the bonds are going to be set at $1,500 each. That's going to be a signature bond through pretrial services. He will report to pretrial once a month. Do you hear that, Ms. Andrews?
Yes, ma'am.
You will report to pretrial once a month. Anytime you change your address, your phone number, or your email, you need to come down and give us that information in writing. You will come down to 160 Prior Street, day 150, and report that in writing so that you don't miss out any future court dates.
Yes,
Understood?
Yes, ma'am.
If you get arrested again for anything else from now onwards, you could also lose this signature bond and it will convert to either a surety bond or a cash bond.
Yes, ma'am.
And we will further notice this case, I guess, for further notice the case to Judge Richardson to see how he wants to address it. Thank you.
And Your Honor, I'm sorry, did we arraign the defendant this morning?
No, we didn't.
Did we
I know
arraign
it
him?
didn't because Mr. Dotis indicated he was filing a waiver of arraignment.
Okay.
Yeah.
Correct.
All right, so I'm just amending it to a $1,500 signature bond to pretrial for each case. And instead of being reset for jail jury, it's going to be further notice for trial before Judge Richardson.
Understood, Your Honor, and I'll submit that bond order as soon as I get out of here today.
No problem. Please email it to Miss Grace, otherwise she'll be after you.
Right, I understand, Your Honor. We don't want that.
Okay, next case, are we going to 4 North or,
Courtroom 2, Judge. Position 17, Mr. Lloyd.
okay?
And Your Honor, Mr. Lloyd has indicated he wanted to ask counsel a question. If I may mute myself for 1 second.
Yes.
Thank you, Your
Okay.
And I was trying to get
Thank
her
you.
here, so I don't know who she is.
There is a lady with a denim jacket on the Zoom panel, Dr. Marsha Clarity. Are you Dr. Clarity?
Your Honor, Ms. Clarity is the mother of one of my clients.
Which one?
I'll have to look and see. I've got several.
3 and 4 is reset further north.
Denaje Stevens.
Okay, I'll be with you shortly then. No, 3 and 4 are going to be taken off because I'm granting the motion to set aside. So those cases should be closed.
Okay.
All right. Ready?
Your Honor, if we could come back to position 17, Mr. Lloyd has a couple of things we need to discuss to clear up.
Okay, so we're going to hold on position 17. Next case, please.
Come on, Mr. Maddox. Put your mask up for me.
And Your Honor, Mr. Maddox is for position 1920 as well as add-on number 3.
Okay. This is State versus Dion Devane Mattox. So position 19 is 21 CR 005764J, in which he's accused of criminal trespass from October 25th, 2021. Position 20 is an FTA case as a result of failure to appear in court, and that's 23 FTA 000106 from January 24th, 2023. And position 3 is a new criminal trespass case, 21 CR. No, excuse me, it's not a new one. It's 21 CR 000422J, accused of criminal trespass from February 1st, 2021. Okay, so I have 2 cases from 2021 and an FTA in 2023. Mr. Maddox, you've been advised of your right to remain silent. Your attorney is Mr. Dotis. On position 19, we have a possible negotiated plea, as well as position 3 on the add-on. And the state will null pros position 2 if the plea goes forward. Is that correct?
Yes, Your Honor, and both of the cases will be negotiated, please.
Okay. Mr. Maddox, could you please raise your right hand? For purposes of the plea, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, Ms. Lewis, what's the plea recommendation for position 19 and add-on 1?
Yes, Your Honor. The state's offer is 12 months to serve 16 days, credit for time served 8 days with the balance suspended, and to stay away from the Holiday Inn Express located at 800 Sidney Marcus Boulevard. For the add-on calendar, offer is the same, 12 months to serve 16 days, credit for time served 8 days with the balance suspended, to stay away from 2452 Morosco Way Northeast. Those positions are to run concurrent.
And the state will null pros the FTA, correct?
Yes, Your Honor.
Thank you. Mr. Dotis, does your client accept these terms for both the cases mentioned? And do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we do so stipulate.
All right. Mr. Maddox, have you consumed any medication or alcohol recently?
No,
And have you understood what's been going on so far?
yes,
Are you satisfied with your attorney?
yes,
And is anyone forcing you to enter a guilty plea today for these cases?
no,
If you decide to take this plea, you would have to give up your right to go back to court, to be able to confront your accuser, have a trial where you could examine witnesses, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes. Am I leaving?
Are you prepared to give up the rights to have a trial in these 2 cases?
Yes, am I leaving?
I'm sorry, are you what?
Am I
Mr.
leaving?
Maddox, just answer the questions, yes or no, and we can discuss. If you have any questions, then I can leave that.
Well, I won't know until I'm convinced that you're entering this plea willingly, knowingly, and voluntarily.
If I could have 1 second on mute, he's just asking when he gets out, this is a time served offer, I'll just convey that more clearly. Thank you, Your Honor.
All right. As I was saying, Mr. Maddox, are you entering this plea willingly and voluntarily? Are you entering a guilty plea willingly and voluntarily?
No, yeah, no,
All right. Do you want to talk to him further, Mr. Maddox?
huh?
Okay, Your Honor, we need to reset Mr. Maddox.
No,
I need to discuss I'm not comfortable going forward with this plea.
I will hold on position 3 on the add-on and position 19 on the main calendar, and you can have a moment to confer with him.
Thank you, Your Honor, and I have a social worker in the room who will speak with Mr. Maddox.
So he gonna.
So you want me to reset it to next Thursday?
We'll just hold, and I'm gonna see, I have a social worker in the room. that
You've got a couple of clients that you want to still say you want to revisit their decision to enter a plea. Did you want to have a powwow with Mr. Maddox so that he understands? I understand if you want a social worker to speak with him. I totally get that. But if you want a moment to confer with him to make sure that he's at least has a reasonable understanding of what's going on, we can proceed. But if you believe that you need the intervention of a social worker, that's a whole different ballgame.
Right, Your Honor, I'm just trying to have a third party, I spoke with Mr. Maddox yesterday and we were clear on everything, and I just want more clarity if I could have a second to talk to my client, and then we can decide where to go.
Okay, I can hold, and then if we still need to reset, I'll make that decision then also.
Thank you, Your Honor. Can we move on to a different position while I speak with Mr. Maddox?
Certainly.
Okay.
Go ahead and have a seat over here, Maddox. Position 25, Perkins. You done?
This is State versus Stephen Perkins, 23 CR 007 0007278. Mr. Perkins was cited with willful obstruction, accused of willful obstruction of an law enforcement officer, operating a vehicle with no insurance, driving with an expired or no license plate or decal, driving while license suspended or revoked, acquiring a license plate for purpose of concealing the identification of a motor vehicle, and failure to have license on person. 1, 2, 3, 4, 5, 6. This is going to be a negotiated plea hearing. Mr. Perkins, you've been advised of your right to remain silent. Your attorney is Mr. Mike McLean. And may I place you under oath for purposes of this hearing? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Well, I love the thumbs up, but I need to hear yes.
Yes.
Okay, thank you. Ms. Lewis, what is the recommendation for all these charges?
Your Honor, the state's offer is 12 months to serve 26 days, credit for time served 13 days with the balance probated with a $500 fine.
All right, that's a little different from what I have. Is that are those the terms, Mr. McLean?
I believe you wanted to. Your Honor, he would like to plead guilty. He stipulates the 3 elements that are necessary, and in terms of the $500 fine, he would like the court to convert that to 50 hours of community service if possible.
Any objection from the state?
No, Your Honor.
All right, and Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Perkins, have you consumed any medication or alcohol recently?
Oh, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And have you understood and are you satisfied with your attorney presently?
Yes, ma'am.
Is anyone forcing you or inducing you to take this plea today?
Oh, ma'am.
And are you doing so freely, willingly, and voluntarily?
Ma'am.
With the understanding that if you enter a plea today, that will close out the case and you will be placed on probation. You will also not have the right to go back to court to have a trial in front of a judge or a jury where you could possibly confront your accuser, examine witnesses, challenge the state's evidence, present any defenses you may have if you choose to do so, and have the state try to prove these charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Has it been explained to you by entering a guilty plea that this could have an impact upon your driver's license as it presently stands?
Yes, ma'am.
I don't understand the response.
Yes, ma'am.
All right. How do you plead to willful obstruction of an officer, no insurance, no license plate or decal, license suspended or revoked, acquiring a license plate for concealing the identification of a car, and failure to have license on person?
Yes, sir.
Your sentence is 12 months to serve 26 days, credit for time served 13 days. If you have no other holds or cases detaining you at the jail, you will be released within 24 hours and placed on probation. You will have to report to probation next Thursday at 132 Mitchell Street in downtown Atlanta. While on probation, you need to complete 50 hours of voluntary community service. I will waive your probation fees for the month of February and March only. If you do not complete the 50 community hours within that time span, you will continue to report to probation and start paying probation fees. If you complete the 50 hours of community service, your probation will terminate. At all times, you are not to operate any motor vehicle unless you have a valid driver's license, adequate insurance, and proper registration. Thank you.
The 50 hours is going on which charge, Judge?
The 50 hours community service, we're going to put it on the, I'm going to put that 50 hours community service on the willful obstruction.
Understood?
Position 29, Stevens.
This is State versus Denijai, Jaheem Stevens.
How you doing today, ma'am? My name is Denaje Jaheem Stevens.
All right, thank you for correcting me. I appreciate that. Case number 23 CR 0000674C. We are going to waive sounding on the particular offense in this case. Mr. Stevens, you have been advised of your right to remain silent. Anything you choose to say about your case, your statements can and will be used against you. You have a right to an attorney. Mr. Michael McLean is going to be your counsel. Mr. McLean, this is going to be a negotiated plea.
Correct. It is.
And Mr. Lewis will refer to the program as SDET without making reference to the charge, okay?
Yes, Your Honor.
All right. And Mr. Stevens, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. Ms. Lewis, what is the plea recommendation for Mr. Stevens?
The state's offer is 12 months to serve 28 days, credit for time served 14 days with the balance probated, SDET, and to stay away from 7490 Old National Highway, which is a shopping plaza, and the state recommends that he stays away from the entire area.
All right. Mr. McLean, does your client agree to these terms? And do you stipulate to the factual basis, venue, and ID?
We do so stipulate he does agree to those terms, Your Honor. He probably does need a financial break if possible from the court because he is young and will be trying to find a job.
All right. And Dr. Clarity, is this the case that you were attending? Is the screen frozen? Okay.
I think it's fun.
Mr. Stevens, Dr. Clarity, I'm sorry, you need to unmute. I see very pretty nails, but I don't see unmute. No. Okay. Could you please state your name?
Morning. I'm Dr. Marcia Clarity, and I'm Denaje Stevens' grandmother.
All right. Did you want to say anything without referencing the offense?
Okay, I would like to address the court. Denaje has some mental issue going on. I tried to get him help. He was hospitalized twice because they gave him some medication to go get more help. No one would seem to help him because the first thing they told me that he's of age and he needs to pursue it. But I was telling them that he's not quite in his right mind. He talks to himself and he needs some help and I'm
Okay,
trying to get
so
him some help.
I'm sorry to interject, but let me ask you something, Dr. Clarity. What is your field of expertise?
Say that again, please.
What is your doctoral in? What area of expertise?
Education. My
Okay,
PhD is in education.
understood. And Dr. Clarity, do you understand what's happening right now?
Well, I know about the charges because I
No,
called the courthouse and
Do you understand what he and his attorney have decided to do? This is a plea hearing in which Mr. Stevens, through his counsel, have negotiated a recommended sentence with the prosecutor. And he is giving up his constitutional right to challenge the charge in a court of law and enter a guilty plea to this charge in exchange of being on probation and to undertake certain rehabilitation treatment. Do you understand that this is what's going on?
yes, ma'am.
Okay, now your statements, are you telling me that Mr. Stevens is mentally incompetent to make that decision?
Well, I'm telling you that he needs to see, did he see a psychiatrist? Did he talk to someone?
Dr. Clarity, I'm just asking you a simple question. You're not going to ask me questions. I need to ask you, as a family
Okay.
member, are you telling me that this defendant is mentally incompetent to make a decision today?
Yes, in my opinion, I do think so.
Okay, and how long have you known Mr. Stevens?
All his life.
Okay, and I'm sorry, you said you're his
I'm his
mother?
grandmother.
Grandmother.
Yes, his mother died and he just went down here from that.
Okay, thank you. Mr. McLean, do you want to speak to Dr. Clarity before I can proceed?
Yes, Your Honor, if we could have a session where, I could get on the phone and, have her call 404-612-2392.
Okay, I'm on my phone right now because I'm at the courthouse because I was told
You
to
can
come here.
leave the Zoom and then you can call back, get back into the Zoom if you want to talk to the attorney.
Okay, let me write that down.
All right. You can go.
Go ahead and have a second round phone.
So what is the number again, please?
404-612-2392.
2392.
612-2392. It's a 404 number.
404-612-2392.
Correct.
Okay, I would definitely call you. Thank you.
Going back to position 20, Mr. Maddox.
All right. Mr. Dotis, what's the decision on positions 19 and add-on 1?
Yes, Your Honor, we're gonna
Add-on
request,
3.
a 1-week reset.
Reset to February 23rd. On position 19. Position 20 and add on position 3.
Thank you, Your Honor.
And is it going on our regular calendar or is it going on the competency calendar?
It's going on the regular calendar.
All right, thank you.
Thank you.
Go ahead, Maddox, go back and sit in the second row. phone.
Next case, please.
Going back to position 12, Lindsay.
It's 12.
And position 12, oh, pardon me, Your Honor.
Go ahead.
I was just saying that position 12 will be a negotiated plea. I've gone over the paperwork with Mr. Lindsay, and I will send it as soon as I get out of the courtroom.
All right. So are we ready to move? Are we ready to move forward with the plea hearing or?
Yes, Your Honor.
Okay. This is State versus Amin Hassan Lindsay, case number 23 CR 0000703F. Mr. Lindsay has been advised of his right to remain silent, and his attorney is Mr. Dodas. Mr. Lindsay, may I place you under oath for purposes of the plea hearing? Right hand. Thank you. The other one. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Okay. Mr. Walker, what's the recommendation for Mr. Lindsay?
The state's offer is 12 months to serve, 28 days, credit for time served, 14 days, balance suspended with the conditions of a stay away of 1329 Willow Trail Southwest, and no further contact with the victim, Lindsay Kareem. Last name is spelled Kariem.
All right, thank you. Mr. Dodas, does your client accept these terms, and does he stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we do so stipulate.
Thank you. Mr. Lindsay, have you consumed any medication or alcohol recently?
No.
And have you understood what's been going on so far? Are you satisfied with your attorney? Could you speak a little louder, sir?
Yes.
Okay. And is anyone forcing you or inducing you to plead guilty today?
No.
And has it been explained to you that if you decide to take this guilty plea, that you would have to give up your constitutional right to a trial? You will not be able to have the assistance of an attorney to go back to a courtroom, to challenge the state's evidence, present your own defenses if you choose to do so, to confront your accuser, examine and cross-examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Do you understand that these are the rights you will have to give up?
Yes.
How do you plead to one count of criminal trespass?
Guilty.
Repeat.
Guilty.
Your sentence is 12 months to serve 28 days, credit for time served 14 days. Your time at the jail is concluded for this case, and if you have no other holds at the jail, then you should be released within 24 hours. Upon release, you have to stay away from 1329 Willow Trail, Southwest Atlanta, and you have to stay 200 yards away from Lindsay Kareem. You're not to communicate with this person in any way, form, or manner. If you engage in any form of communication, you could be arrested again. Do you understand? Yeah, Lindsay is Lindsey.
Your last name is Kareem. Is that-
Kariem.
They got the same.
All right, Mr. Walker, just to clarify, the victim's name is Lindsay Kareem as opposed to Kareem Lindsay, correct? No connection
It could
to,
be Kareem Lindsay. I might have it reversed.
Your Honor, I'm looking at the accusation. It should be Kareem Lindsay. I think we just switched.
Yeah.
all right,
I'm
good
sorry, I
catch,
missed
Ms.
that.
Grace. Miss Grace was the one who pointed out you could have the name wonky, so thank
Thank
you.
you. I had it
Thank you,
inverted.
Ms. Grace.
All right. All right, next case, please.
Position 21, McCullough.
Mr. Dodas, is that your client? Mr. McLean?
Client is walking over.
All right, and Mr. McLean, how are we proceeding in this case?
Let's see, Mr. McCullough is number 21, and that's a negotiated plea, Your Honor.
Okay,
And in that negotiation, there's a $300 fine, and he would ask the court to convert it to 30 hours of community service.
and does the state have the amount of restitution?
One moment, Your Honor.
If they're asking for it, I'm just looking at my notes.
What position is this, Your Honor?
21.
Okay, one second.
Oh, no, no.
Alyssa, they're all here if you need them.
Okay.
Gotcha.
All right, Ms. Lewis, while you're looking to see if there's restitution, I'm going to proceed with the opening of this case. This is State versus Shamir McCullough, 23 CR 0000853A. Mr. McCullough has been advised of his right to remain silent, and his attorney is Mr. Michael McLean. This is going to be a negotiated plea hearing for the following offenses: hit and run, failure of the driver to stop at or return to the scene of the accident, operating a vehicle with no proof of insurance, no driver's license, and failure to obey a traffic control device. This incident allegedly occurred in Fulton County, Georgia on January 27th, 2023. Mr. McCullough, if you please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Lewis, are you ready for the recommendation?
I am. I think Mr. Walker's looking for the restitution, but I'm ready to give you the rest of the offer.
Go ahead.
The state's offer is 12 months to serve 10 days, credit for time served 5 days with the balance probated, a defensive driving course, and the state has no objection to converting the fine to 30 hours of community service.
And there's no restitution, Your Honor.
All right. Thank you. Mr. McLean, are those the terms to which your client is accepting? And do you stipulate to the factual basis, venue, and ID for this case?
We do so stipulate, and he does agree to those terms. Thank you.
Thank you. Mr. McCullough, have you consumed any medication or alcohol recently?
Medication, yes.
And in consuming that medication, are you still able to understand the proceedings so far?
Yes.
And are you satisfied with your attorney?
Yes.
And is anyone forcing you or inducing you to take this plea today?
No.
Has it been explained to you that in entering this plea, that you give up your right to go back to court and have a trial in front of a judge or a jury, that you will not be able to have the assistance of counsel so that you can confront your accuser, examine witnesses, challenge the evidence brought against you, present any defenses you may have if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes.
And has it been explained to you by entering such a plea, it could have an impact upon your motor vehicle record as well as the status of your driver's license?
Yes.
How do you plead to one count of hit and run, failure to return, stay or return to the scene of an accident, no proof of automobile insurance, no driver's license, and failure to obey a traffic control device?
Guilty.
Your sentence is 12 months to serve 10 days, credit for time served 5 days. Your jail time for this particular case is closed. You will be released if you have no other holds at the jail and placed on probation. You will report to probation next Thursday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While on probation, you will report every month, and you will complete a defensive driving course that is approved by the Department of Driver Services. You will also complete 30 hours of community service that can be completed at any nonprofit agency, which is not a school and not a religious organization. Do you have any questions?
No.
Anything else, Mr. McLean?
Nothing, Your Honor. Thank you.
That
30 hours is going on what,
30 hours is going to the hit and run. Thank you.
Positions 30 and 31, Thompson.
This is Solomon Thompson, case number 22 CR 004972B, in which Mr. Thompson is accused of criminal trespass and willful obstruction of an officer from July 27th, 2022. In his second case, 23 FTA 000107, this was for a failure to appear in the case I just mentioned on July 27th, 2022. Okay, I'm a little confused. I think the failure to appear must have been on a different date. Mr. Thompson, you have a right to remain silent as so advised, and your attorney is Mr. Mike McLean. This is going to be a negotiated plea. Is the state going to null cross position 31 as a result of the plea?
Yes, Your Honor.
Mr. Thompson, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Lewis, what is the recommendation for Mr. Thompson?
The state's offer is 12 months to serve 8 days, credit for time served 4 days with the balance probated, to stay away from 51 Peachtree Street, which is Georgia State University, and that is the entire campus or all the property of Georgia State, and a $300 fine.
There's balance probated, okay. Mr. McLean, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID for position 30?
You know, I had brought to him a balance suspended plea, so I need to talk to him. And
And have the terms changed? Because that's what I have, balance suspended on my calendar.
right,
That was an error when we sent it over. It was balance probated because of the fine.
Okay,
so, and by the way, I noticed that also about the offense date on number 31, but it's irrelevant because there's no.
I'm sorry, Mr. McLean, could you repeat that? It was a little muffled.
I said, I noticed the oddity of the offense date being what it is on the number 31 position, but.
Yeah, I'll look into that. I'll look into that.
It won't matter in the long run because that'll get all problem.
Correct. So do you want to hold until you confer with your client?
I do. There's a place in the courtroom where I can talk to him.
Okay, thank you. Yeah, all right, let's move on to the next case, please.
I'll talk to him later.
Position 32, Thornton.
You know, this is going to be a negotiated plea of guilty. We have some discussions this morning and we're in agreement.
This is Corey Dion Thornton Jr., 23 CR 000-830J, in which Mr. Thornton was accused of simple battery family violence from May 8th, 2022. Mr. Thornton, you've been advised of your right to remain silent. Your attorney is Mr. McLean. And may I place you under oath? Mr. Thornton, may I place you under oath? Raise your right hand.
So just.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Thank you. Ms. Lewis?
The state's offer is 12 months to serve 283 days with the rest of the balance probated, 6 weeks of anger management, 40 hours of community service, and no further contact with Erica Ware, who is the victim in this case.
Spell the last name, W-A-R-E?
Yes, Your Honor.
Thank you. So it's not FWIP, it is 6 weeks of anger management classes, 40 hours community service, and no further contact. Mr. McLean, are those the terms to which your client has agreed?
Those are the negotiated terms, Your Honor, yes.
And do you stipulate to the factual basis, venue, and ID?
We do so stipulate, yes.
Does he have any other holds?
Not that I'm aware of. I don't think so. And we don't think he will pop up either.
Repeat, please.
None that we're aware of, and we don't believe any will pop up either. I think he's fine on it.
Okay, all right. I see that I have Corey Thornton's mom. Miss Thornton,
Yes, ma'am.
my name is Judge Lal. We are addressing a plea hearing with Corey Thornton Jr., in which he's going to be pleading guilty and placed on probation. Did you want to add anything?
I do. My son is suffering from schizophrenic.
Oh, great. Okay. Hang
Yes,
on.
ma'am.
All right. And so, Mr. McLean, we have another family member who is questioning the defendant's competency.
It would appear so.
All right. What's your name, please, ma'am?
Herring Thornton, Jennifer Herring Thornton, I'm sorry.
Karen Thornton. Okay.
Yes,
All right. Miss Thornton, are you able to write down this number?
yes, ma'am. Let me get a pen right fast. Oh, I am so ready.
404-612-2392.
All right.
And you need to speak to Mr. Michael McLean.
All right.
He is the attorney seated at the jail right now in the courtroom.
Okay.
And
It might actually be necessary to do a breakout room. We do have quite a number.
we can only do that at the conclusion of all the other cases seated back there.
Okay, that works for me.
All right.
Thanks.
All right, Ms. Thornton, if you'd like to mute your screen until Mr. McLean's ready to speak with you, that would be good.
And
Yes, ma'am.
if I can make an announcement on Mr. McLean's other client, Mr. Stevens, I believe that's the defendant whose grandmother is on the line. After re-reviewing that case and the allegations and hearing the testimony of the grandmother, the state is revoking the offer. I don't know how they would like to proceed after speaking with the defendant's grandmother, but as of right now, the state will be offering 12 months to serve, and in the alternative, we'll be requesting a competency evaluation. But it will have to be non-negotiated if they do proceed with a plea today.
All right, Mr. McLean, I don't know if you've spoken to Dr. Clarity yet, but the state is revoking its offer for position 29.
Well, I'll speak with him about that, Your Honor, because he did accept their plea bargain offer before, and we'll decide whether or not we want to enforce that. So stay tuned.
All right. All right, I'm waiting to get back to that case. Courtroom 2, I'll take the next case, please.
Are we coming back to this case? Okay, go ahead and have a seat. Position 33, Tiller.
This is State versus Curtis Eugene Tiller, case number 21 CR 003984J. Mr. Tiller was accused of the following charges: possession and use of drug-related objects, criminal trespass, fare evasion, and violation of certain rules at the bus, rail, or station. This is from a July 30th, 2021 incident. Does Mr. Tiller? This is, Mr. Tiller does have a second case, which is an FTA case, a failure to appear. It's a 23 FTA 000108. So which the state will null pros if the plea hearing goes forward with regards to position 33. Mr. McLean, is your client still going to move forward with a negotiated plea?
He is, Your Honor. We do stipulate to venue and ID on a factual basis.
And all of that, okay. Mr. Tiller, may I place you under oath? Other right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Lewis?
Yes, Your Honor. The state's offer is 12 months to serve 4 days, credit for time served 2 days with the balance suspended, and to stay away from the Ashby MARTA station, which is located at 65 Joseph E. Lowry Boulevard.
Does he have a stay away suspension right now from MARTA? No, actually, I'm asking Ms. Lewis or Mr. McLean, if you know.
12 hours on the citation.
Hold on one moment, Your Honor.
The reason I'm asking is, Ms. Lewis, can I do the stay away from the Ashby MARTA station in accordance with any active suspensions?
Yes, ma'am, I stay away.
That's fine, Your Honor.
No, I was asking the prosecutor, sir.
He said if I stay away a year.
Do you remember?
Yeah, no.
You remember what I said?
Yes,
Your Honor,
sir.
he had an active suspension, but it's already been lifted.
So how long do you want him to stay away?
He said, yeah. On the side.
If the suspension's been lifted, he can return, Your Honor.
Okay, thank you, Mr. Walker. So it's going to be stay away from the Ashby Model Station in accordance with any active suspensions. So if there are no suspensions, he can use the Model Station legally. And if there is an active suspension, he should not return because then he'll be arrested again. Mr. McLean, is that your understanding?
Yes, Your Honor, it is.
And Mr. Tiller, do you understand what I just said?
So what day next year, 24th? Can I get back on, Mark?
If you have an active suspension until 2024, then you cannot return to the Ashby Model Station.
So February the 16th.
I'm sorry, I don't understand his comment.
He was saying till February the 16th because he was looking at the fence date and the arrest date, so.
All right. Typically,
arrest
these
is better.
suspensions go model wide. That means he cannot use any model. So if that's his understanding, I hope he'll verify that as well.
Very good.
Okay. In that case, then, Mr. McLean, does your client, do you stipulate to the factual basis, venue, and ID?
We do?
Mr. Tiller, have you consumed any medication or alcohol recently?
Well, I have been on medication, but I go back, 10 parts.
Okay. And if you've consumed any medication, are you still able to understand what's going on?
Yes,
And have you understood and are you satisfied with your attorney, Mr. McLean?
yes,
And you understand that if you enter this guilty plea to these charges
yes.
from
ma'am.
the Ashby Model Station, that you will not have a trial in the future.
Yes, ma'am.
You will not be able to go back to court and have the assistance of an attorney so that you can challenge the evidence brought against you. You can confront your accuser. You can examine witnesses and have the state try to prove the charges against you beyond a reasonable doubt. These are your rights and you must give them up if you want to plead guilty today. Are you prepared to do so?
I say yes.
Are you entering a guilty plea freely, willingly, and knowingly?
Yes, ma'am. Yes,
How do you plead to the 4 charges I've just listed?
yes,
Your sentence is 12 months to serve 4 days, credit for time served 2 days. The balance is suspended. That means you don't have any probation. But you have to stay away from the Ashby Model Station if there's any active suspension presently. And you might want to also check with MARTA headquarters at Lindbergh, I don't remember, Lindbergh Drive in Atlanta, to make sure exactly when your suspension ends and how far, which stations can you otherwise visit?
no station at all.
Oh, okay. So then you have to stay away from all MARTA until your suspension's over. Okay. Thank you, sir.
But I go to jail?
What was the question, Mr. McLean?
He was wondering if he has any more extra jail days, I believe, but,
Nope, it's closed. You'll be released within 24 hours if you have no other holds, no
Thank
other
you.
cases. Thank you. Good luck.
Okay, thank you.
Okay. Next, Your Honor, we have position number 36, Mr. Russian. 36.
Has Mr. Dodas completed conferring with the attorney, with the clients who are on hold?
Your Honor, we need to readdress, I think, position 17, Mr. Lloyd, quickly, but
Okay,
if the jail staff wants to do that, I'll let them run the show.
okay. State versus Donald Rushin, 17 CR 027600F. Mr. Rushin is been accused of DUI under the influence of alcohol per se, DUI driving under the influence of alcohol less safe, aggressive driving, and failure to maintain lane from an April 22nd, 2017 incident. Mr. Rushin, you have been advised of your right to remain silent, and your attorney is going to be Mr. McLean. Is this going to be,
a negotiated plea, Your Honor.
all right?
Of the 2 DUI counts, it'll be per se, and the less safe will be no pros.
Okay. Mr. Rushin, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Lewis, what's the plea recommendation?
The state's offer is 12 months to serve 14 days, credit for time served 7 days with the balance probated, ADET, as well as a risk reduction class and 40 hours of community service. Nothing further.
Is the state, now I'm just, the only reason I'm mentioning this is because it was printed on the calendar, and whatever's printed on the calendar is not binding if there's a mistake. I've got a $300 fine. Is the state not pursuing that?
We are pursuing the $300 fine.
All right, there's a $300 fine also. The last one is a victim impact panel, one victim impact panel. Is the state pursuing that?
Yes, Your Honor.
Okay. All right, Mr. McLean, in addition to what Ms. Lewis said, there's also a requirement of a $300 fine and one victim impact panel. Are those the terms to which your client has agreed?
Yes, Your Honor, he would like to ask to convert the $300 fine into 30 hours of community service.
Any objection, Ms. Lewis?
No, Your Honor.
All right, and anything else? Otherwise then, does your client agree to the terms?
I'm sorry, Your Honor.
Otherwise, does your client agree to the terms?
Yes, Your Honor.
And do you stipulate to the factual basis, venue, and ID?
We do.
Mr. Russian, have you consumed any medication or alcohol recently?
No, ma'am, I haven't.
And have you understood the proceedings as they've been going on so far?
Yes, I have.
Are you satisfied with your attorney?
Yes, I am.
Is anyone forcing you or inducing you to take this plea today?
No, no.
And has it been explained to you that pleading guilty to a DUI could have a negative impact upon your driver's license and motor vehicle record, as well as have an impact upon your residency if it's applicable, any professional licenses you may have, your job situation?
Yes, ma'am.
Are you still prepared to move forward with this plea?
Yes, I am.
And has it been explained that in entering such a plea, you give up your constitutional right to go back to court, to have a trial with regards to these charges, to be able to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt?
Yes, ma'am.
How do you plead to DUI under the influence of alcohol per se and aggressive driving?
Guilty.
All right. I understand the state is going to null pros the DUI less safe and the failure to maintain lane. Is that correct?
What does that mean? What does that mean? You're gonna
No
Yes,
problem.
sir. We're no crossing the less safe, Your Honor, not the failure to maintain lane.
Oh, I'm sorry. So, so it's a guilty plea to DUI per se, aggressive driving and failure to maintain lane?
No, I'm not understanding. Are those charges getting dropped, or I'm not understanding it?
No.
Ms. Lewis, please clarify, to which charges is the state seeking a guilty plea?
The per se, Your Honor.
The per se, the aggressive driving, and the failure to maintain lane, Your Honor.
Okay, thank
So
you.
it's 2 charges, not 1 charge.
2.
I think you're speaking of the DUI portion of it. It was 2, but they're in the alternative one, so it becomes 1. The other charges remain the same.
So this DUI and the maintain, it's the greater charge of the, I'm sorry. It's
One is not greater than the other, but I explained it to you
But that's what it
before.
says on there. It says less or greater, so one that says greater.
No,
is
less,
greater.
less safe is not a lesser included offense. You're confusing legal terms.
Okay,
That's
so
not
the
what
greater, so
they-
the greater term is dog. Bill of rights, that's what I'm getting guilty charged on, correct?
It's per se. It's a Latin phrase.
I speak English, I don't speak that.
Okay, we're,
So the greater charge is Donald Bill of Russian, correct? I'm asking, I don't know. I mean, that's why I have a attorney here. So the greater charge is Donald Bill of Russian. Okay. And then you're gonna have an additional charge that they have to accept, which is maintain lane, correct?
the charges that are there, one of those 4 charges, 4 charges will be gone. The charge that will be gone is the less safe.
Okay, so, okay.
The others remain.
The lesser charge is gonna be gone.
I don't refer to them as lesser charges because they're all
The
misleading.
DUI that says less is gonna be gone, and then the maintain lane and aggressive driving, those are gonna be gone also.
No, they are not. Those remain.
So which, I'm asking, I'm doing, I'm,
Are you ready to listen?
yes, ma'am.
This plea recommendation means that in exchange for the recommended sentence, you would be pleading guilty to DUI per se, 1 count.
Okay.
Second count, failure to maintain lane. The charges of DUI less safe and aggressive driving will be closed out and not held against you.
Okay, okay, I understand that, yeah, so that, but I was thinking, I didn't know they added on to maintain the lane. So that's why I thought it was, I thought it was dropping all 3, and I just was gonna be charged for the 1. But now I understand that now, but that's what we was there, as far as the plea bargain, was just I was gonna have 1 charge and the other 3 charges that was gonna be dropped out. You know, and not split, not sort of say split, you know, it's like split even for the money. But I understand, I understand that, so I plead guilty to all that. I just have to make sure I have an understanding. So when the charge on there or become around, I have an understanding. As long as I understanding, then I can work.
Mr. Rushan,
But I plead guilty to the charge that they are.
how do you plead to 1 count of DUI per se?
Guilty.
How do you plead to 1 count of failure to maintain lane?
Guilty.
Those are the only 2 charges which will show up on your motor vehicle record as a conviction.
Okay, that's fine. No, yes, that's fine, that's fine.
DUI driving under the influence of alcohol less safe is null pros. The aggressive driving is null pros. Your sentence for the 2 remaining charges is 12 months to serve 14 days, credit for time served 7 days. The balance will be probated. If you have no other cases holding you at the Fulton County Jail, you will report to the probation office next Thursday, February 23rd, 2023, before 3 p.m. And when you report to the probation office, they will place you on probation where you will have to complete 30 hours of voluntary community service at any nonprofit agency, which is not a religious organization and not a school. You can do it at any other nonprofit agency like Salvation Army, Goodwill, Animal Rescue, so forth. You must complete 1 alcohol and drug evaluation with a qualified healthcare provider and submit yourself to any treatment that's required by the evaluator at your expense. You must complete 1 risk reduction program. And you must also complete an additional 40 hours of community service. So because I've converted your fine to 30 hours, so your total obligation for community service hours is now 70 hours of community service. And you will attend and complete 1 victim impact panel. Your probation officer will instruct you on when and where to attend the panel.
Okay.
Do you have any questions about your sentence?
No, not at this time.
I beg your pardon?
No, not at this time, not at all.
This is your sentence, and don't forget to report to probation next Thursday. Thank you.
Thank you. All right, okay.
Going back to position 17, Lloyd.
Timothy Lloyd.
Jamasco.
Mr. Dotis, this was going to be an arraignment, I think, and then your client decided to take a plea. Are we ready to proceed?
No, Your Honor, we were just, my client had some questions that I wanted to clarify before. We will still be waiving his arraignment today.
All right.
Apologies if I
This is
wasn't.
going to be a waiver of arraignment. Mr. Lloyd, your attorney will submit a not guilty plea and waive arraignment, and your case will be reset for jail jury. Anything else?
Nothing further from us, Your Honor.
All right, thank you.
Going back to position 32, Thornton.
All right, Mr. McLean, you've conferred with Ms. Karen Ponton. How would you like to proceed?
No, Your Honor, we have not conferred at all.
I was waiting for someone to tell me that it was time to call.
We're probably gonna have to do a breakout at the end of
Okay.
the session with Ms.
All right. Francois, have we addressed everybody else in the jail?
Yes, we have. The only ones that are left are here in courtroom 2. And I also have positions 30 and 31, Thompson, also position 29, Stevens. And then after that, it will be the competency.
Okay. I'm going to go down the calendar and then just get a snapshot of what cases remain due to the council having to confer with outside parties. On the add-on calendar, position number 1, Coakley is a waiver of arraignment, reset jail jury. Position 2, Horsch is a waiver of arraignment, reset for jail jury. And position 3, Maddox is reset to February 23rd for a possible plea. On the main calendar, position number 1, 2 are going to be further notice for trial. Council will be filing a waiver of arraignment, and the bonds modified to a signature bond through pretrial. So both those cases will be further notice for trial, which means positions 3 and 4, the motions to set aside the bench warrant are granted, and these cases are closed. So Mr. Dotis, you will need to submit a proposed order for all 4 cases, okay?
Understood, Your Honor. Thank you.
Thank you. Position 5, 5, 6, and 7, Narraton Brooks, also known as Lindsay, I believe. Those 3 cases are going to be, this is going to be a waiver of arraignment.
Yeah.
And these are all reset for jail jury.
Just to break up them.
All right, position number 8, Regina Curry. That's going to be at the Union City location.
Yes, sir. I think we're waiting for them to hop on Zoom.
Okay. Position number 9, Kenneth Freeman was a waiver of arraignment, reset for jail jury. Position number 10, 10 and 11, that's Kellon Lewis, and that's going to be reset. I'm going to reset it to the competency calendar or just reset for evaluation.
Is this, pardon me, I was,
Kellon Lewis.
if we could just put him out a week onto the regular SAP calendar.
How long?
Is it going to be on March 1st? March 2nd, excuse me.
Is this, I would request February 23rd, just on the next SAP Thursday calendar.
All right.
No, it's getting full.
Mr. Dotis, I'm concerned we have already overburdened that calendar. You'll have to be March 2nd pending the evaluation.
Understood, Your Honor. Thank you.
So positions 10 and 11 are reset to March 2nd pending evaluation. Position 22 is a negotiated, no, hang on. It was supposed to be a plea. Did we complete that? Okay, so that was a plea. Position 13, 14, 15, and 16. Position 13 was a waiver of arraignment. This is going to be reset for jail jury. The motion to amend the bond was denied.
Third row, I need you guys to say the second row. You're in the third row, sit the second row.
And then position 14, 15, and 16 are reset to February 23rd to address the defendant's motion to set aside the bench warrant. Position 17, Timothy Lloyd was a waiver of arraignment, reset for jail jury. Mr. Dotis, are we still addressing that case this morning?
Mr. Lloyd's case?
Yes, Timothy Lloyd.
Yes, Your Honor, we waived his arraignment earlier today.
We just did it, Judge.
Okay, just wanting, you gotta refresh my memory, okay?
Understood, Your Honor, apologies.
No problem. Position 18, has been released and reset further notice. That's Angel Marcos. All right, now position 19, and 20, which is Dion Matix. And add-on position 3, Mr. Maddox as well. All 3 cases are going to be reset February 23rd. And that's for a possible plea or possible evaluation, okay? Pending evaluation. Position 21, McCullough was a plea. Position 22, Andrea Moore. And that's going to be at the other calendar. And that's, and who represents her?
Attorney McLean represents her.
Yeah.
All right. Okay, we're going to address bond there. All right. Position 23, Sampson Parks was a plea. 24, Sampson's Park, position 24 is null prost. 25, Perkins was a plea. 26, Heather Reese is going to be addressed shortly. 27, Samantha Solano, 27 and 28 is going to be addressed also shortly. 29 is Stevens. That was, what are we doing there, Mr. McLean? We're going to talk to.
Position 29. Right, I'm gonna
That's
talk,
where you have to talk to Dr. McClarity.
Dr. Clarity, correct, Your Honor.
All right. And so this is on hold.
It's on hold, that's correct.
Okay. Position 30, Solomon Thompson, was that a plea?
That's a plea. He has decided that the element that he didn't know about, we've discussed the $300 or 30 hours of community service. And he would like to go forward with this plea and complete it with the option of using 30 hours of community service.
All right. Do we do the plea or we still have to do the plea?
We were almost through with it. We stopped
now.
near the end.
Okay. So we have to do position 30, and if 30 goes forward, then 31 will be null prost. Position 32, that's where you are waiting to talk to Ms. Thornton. All right. 33 was a plea. 34 was null prost. 35, Michael Todd.
Release.
Release, thank you. And 36 was a negotiated plea. Okay, so we are holding on position 29 and 32, subject to attorney's conference. We're going to take a plea on position 30, and then we're going to, Deputy Milton, good morning.
Good morning, Your Honor.
We just got one more plea, and then we're going to address your case.
Okay, no problem at all.
Thank you. So let's go to position 30 and 31. All right, resuming the plea hearing with Solomon Thompson, 22 CR 004972B. Mr. Thompson was already placed under oath. He was advised of his right to counsel, advised of his right to remain silent, and the state had provided us with the plea recommendation of 12 months to serve 8 days, credit for time served 4 days, balance probated, a $300 fine, which the court will convert to 30 hours of community service. Is that correct, Ms. Lewis?
Yes, Your Honor, that's correct.
All right, and Mr. McLean, does your client agree to these terms?
He does.
And do you stipulate to the factual basis, venue, and ID?
Yes, we did.
All right, and this is 1 count of criminal trespass and 1 count of willful obstruction of an officer. Mr. Thompson, you've already been placed under oath. May I ask, have you consumed any alcohol or medication recently?
No, Your Honor.
And have you understood your attorney based on the additional discussions you've had?
Yes, Your Honor.
And are you still willing to go forward with this plea? And are you satisfied with your attorney? And is anyone forcing you or inducing you to take this plea offer?
No, Your Honor.
If you'd also decide to enter this plea, you would have to give up your constitutional right to a trial, to go back to court to challenge these charges in a court of law, have the state carry its burden to prove the charges against you beyond a reasonable doubt, and also your rights to confront your accuser, examine witnesses, and present any defenses that you may have and if you want to present them. Are you prepared to waive these rights?
Yes, Your Honor.
How do you plead to one count of criminal trespass and misdemeanor obstruction of an officer? Repeat.
Guilty.
Your sentence is going to be 12 months to serve 8 days, credit for time served 4 days. The remainder of the time you'll be on probation. You will have to report to your probation officer next Thursday at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 30 hours of voluntary community service at any nonprofit agency, which is not a school and not a religious organization. I will waive your probation fees for the months of February and March, during which time you are going to continue reporting to probation and make sure you complete your 30 hours community service. On April 1st, if you have not completed your condition, you will continue to report to probation and start paying probation fees. If you have completed your condition of 30 hours of community service, your probation may be non-reporting.
Yes, Your Honor.
And the most important thing, whether you're on active or non-reporting probation, you have to stay away from all Georgia State University property, every single one. And they have a large campus, so do be careful. Understood? Thank you.
The hours is.
Hang on.
No, the willful obstruction.
Probation. So this is a probation.
All right, Mr. McLean, please talk to Dr. McClarity and Ms. Thornton. I have Mr. Dodas for position 8. As soon as Deputy Milton returns to the,
Your Honor, I also see, we have one client, Mr. D'Anthony White, who I see on Zoom. I think he might be ready for his DV calendar case, if we're still waiting on the South Annex.
all right. Well, the DB bench warrants are normally at 11 o'clock. If he's ready, is that K51?
I believe it's D'Anthony White. I see him on Zoom, and his camera was on earlier. If
Yeah,
he's,
is that the gentleman in the red shirt or jacket? No, okay. I have a D'Anthony White here. Okay. Let's see. This is State versus D'Anthony White, and we are addressing this case via Zoom. 21 CR 000-495G. Mr. Anthony White is present, and Mr. White, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you for these proceedings is going to be Mr. Dodas, who is on the panel titled Courtroom 2. Do you see him? Mr. White, you need to unmute your screen.
I apologize. I see him.
All right. This is a bench warrant that was issued after Mr. White failed to appear in court on December 14th, 2021. The bench warrant was sent again to the defendant on January 10th, 2022, and we had a return to sender. All right, Mr. Dodas, you may proceed.
Yes, Your Honor. Apologies for the background noise. I spoke with Mr. White regarding the incident on December 14th. The issue was there was a bad address. His mailings was going to 2216 Point View Drive, apartment D. That's no longer his address. A good address now is the one he listed on the inquiry notice, and I'm happy to put that in the chat. I confirm that as well as his telephone number and his email address. Mr. White did not intend to miss court. He just did not receive the notice, and he assumed that the court knew that his address changed, but I've been very clear with Mr. White that he needs to stay on top of that. It's no one's job except his own to make sure the court knows how to find him, as well as if he hasn't heard anything within a month, then he needs to be proactive and reach out to the court to make sure that they aren't looking for him. I don't believe that Mr. White is, this case occurred in 2019, and I don't think there's been any subsequent issues either with the alleged victim or any other violent acts. So I don't believe Mr. White is a danger to the community or any witnesses or the victim. So we would just ask to have this set aside now that we have a good address and Mr. White is clear on what he needs to do to ensure that the court can find him.
All right. Ms. Lewis, do you have a DCIC with regards to Mr. White? Have there been any other incidences since 2019?
No, Your Honor, not that I could find.
All right. Do you have an objection to setting aside the bench warrant?
Yes, Your Honor, the state does object to setting aside the bench warrant. We understand the address was wrong, but however, it is always the defendant's obligation to their obligation to know what's going on with their own case. So the state is objecting that set aside.
All right. And Mr. Dotis, Mr. White qualify for the services of the Public Defender's Office? Are you going to continue to represent him?
Yes, Your Honor. After speaking with Mr. White before this hearing, he does qualify. Apologies for not bringing that up earlier.
Okay. All right, Mr. White, I'm going to grant the motion to set aside the bench warrant. Your bond is actually going to be amended to a $2,000 signature bond through pretrial services, which means that you're going to take your bond order as soon as it's signed and filed, and you're going to report to the pretrial services division. Mr. Dotis, you will need to give him the address of the pretrial services office. You can contact Ms. Dory Mann, Jorimann, to get that information. Mr. White, after today, you will report to pretrial. Your first appointment must be no later than February 28th, 2023. And then thereafter, you will report every month. You're also responsible for making sure that your address, your phone number, and your email are current with the court at all times. It's a big flaw on the defense part to assume that the court automatically knows when you move or change address. There's no way of keeping track of that. If you change address, you're responsible for letting the court know, because you're responsible for making sure that you get the notices. Do you understand, sir?
Yeah. Yes.
Okay. All right. So you'll be reporting to pretrial, and your next court date will be sent by the court to your current address at Peak Road, was it?
Yes.
Okay. But keep in touch with Mr. Dotis, because you'll need to report to pretrial services.
All right, thank you.
Mr. White, I'll be emailing you and giving you a call later this afternoon with that information.
All right, thank you.
Yes, sir.
All right. Okay, moving on to position 8 on the main calendar. Is Regina Curry at South Annex? Regina Curry, okay, that's you. All right. And ladies, my name is Judge Lal, and this is going to be the state all-purpose calendar where we're going to address the status of your cases. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and if you qualify, one of the public defense attorney counsel will be representing you, which is either Mr. Dotis or Mr. McLean. So addressing position 8, Regina Curry, 23 CR 000692E. Ms. Curry was accused of criminal trespass, 2 counts, on February 1st, 2023, with regards to a Marta location. Ms. Curry, you've been advised of your right to remain silent. Your attorney is Mr. Dotis, And this is going to be a negotiated plea. Is that correct, Mr. Dotis?
Yes, Your Honor, and we do stipulate to the factual basis, venue, and ID purpose.
Thank you. Ms. Curry, if you please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony provided will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Walker, what's the recommendation for Ms. Curry?
The state's recommendation is 15 days time served with the condition of remaining compliant with any active MARTA suspensions.
All right. And Mr. Dotis has stipulated to the factual basis, venue, and ID. Does your client also accept these terms?
Yes, Your Honor.
Ms. Curry, have you consumed any medication or alcohol recently? You need to say yes or no.
No, no, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes.
Is anyone forcing you to take this plea today?
No, ma'am.
Has it been explained that if you enter a guilty plea to these charges, you will have to give up your constitutional right to go back to court and have a trial where, with the assistance of counsel, you could have the opportunity to challenge these charges in a court of law, confront your accuser, examine witnesses, have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of criminal, to 2 counts of criminal trespass? Your sentence is 12 months to serve 15 days, credit for time served 15 days, balance suspended. If you have no other cases holding you at the jail, you should be released within 24 hours. Please keep in mind that you have to stay away from all MARTA property if you have any active MARTA suspensions against you. The best way to verify that is to check with MARTA headquarters at Lindbergh Drive in Atlanta to see if you have any active MARTA suspensions against you. All right?
Right. Thank you.
Thank you. All right, who do we have next to her?
Next, we have, Ms. Reese, position 26. Have a seat, oh, dear, best for you. Come on, look closer, Ms. Reese.
And
All right, the remainder of the cases, 22, 26, and 27 and 28, handled by Mr. McLean. Mr. McLean, you were in conference with the other folks. Are you prepared to move forward?
I'm prepared to move forward there. I see on the camera, I see Ms. Reese. Do you want to go ahead and do that not guilty plea?
All right.
May I speak to my attorney for a moment?
Repeat, please.
May I speak to my attorney for a moment?
Yes. Miss, oh boy. Deputy Milton?
Yes, ma'am.
Is there a way for Miss Reese to call the Fulton County Jail Courtroom 2 at 404?
I'm sorry, 404 865
404-865
8114.
8114. All right. Mr. McLean, Miss Reese would like to speak to you. Did you get the number?
It's a 404-865-8144.
8114. I'm sorry. Is it 8114 or 8144?
8114.
Okay, very good. I will find a phone somewhere and give her a holler.
All right. Deputy Milton, it's going to be a few moments. Mr. McLean has 2 other folks he has to talk to.
Okay, Your Honor, in regards to the composite calendar.
Position 22, that would be
okay.
Andrea Moore. Is she present today?
Who?
Position 22, Andrea Contricia Moore.
I don't have her down. Oh, Miss Moore, she is at Alpharetta Jail.
All right.
Position 27 and 28 is at Alpharetta Jail.
Do you know when they will be brought over?
I don't know. But on the competency calendar, I was told I have to bring around Miss Monica Brown, position 2, position 14, and position 15.
Okay.
Okay,
just hang
I'll
on.
be right back. I'll be right back.
Your Honor, I think we have a solution to some of our logistics.
Just give me a moment, please.
Karen Daniels.
All right, Mr. McLean, go ahead.
Mr. Dotis and I can go into a room and I can borrow his computer to do a breakout room in the medical section. It's quiet there. There are no offices or cubicles there. It'll be private, confidential. So we can do a breakout session from right there. It's only a few feet away from us across the hallway.
All right, go ahead. I thought I saw Mr. Dotis. Oh, there he is.
Sure.
Okay, I see him on his laptop. Yeah. Once you on that room, I can put you in a breakout with Mr. Reese. If you'd like to underlay now, we can.
Perfect. It's just PD Angelo Dotis on Zoom.
All right.
And Your Honor, that would also work for Dr. Clarity to do the breakout. with Dr.
She's
Clarity.
she's not on the screen. You need to call her.
I'll call her.
And then in the interim, Your Honor, would you like to do the competency calendar?
Yeah, is Mr. Derek Howard ready?
I see him on the line, but his screen is turned off.
Your Honor, for the competency calendar, position 2,
14 and 15?
and 15, and possibly position 9. She inquired of if she has to come, that she wants to come to court. It's as soon as I finish with Judge Dunaway courtroom and with this calendar, I have to go down and get those other ladies.
Okay, that would be fine. Mr. McLean, let's see if you can get into the room because we need to put you in a breakout with South Annex since Deputy Milton is juggling multiple Zooms.
I've got my laptop ready. As soon as we can put PD Angelo Dotis South Annex in it, I'll give Attorney McLean my laptop to step out. And then Mr. Walker, Derek said just a minute to before the competency calendar, so might take a second.
All right, as soon as Mr. Howard's ready, I can have us move into our own breakout for, I have this gentleman here with a red jacket, K51. I have no idea who he is. Mr. K51, which case are you here for? And you're upside down right now. Need to unmute?
Yeah, Ms. Andrea Moore.
Andrea Morton.
Andrea Contricia Moore.
Yeah, she's,
That's going to be a non-guilty plea.
all right. So Miss Andrea Contricia Moore, is that correct?
Right. I do need him for a bond hearing.
1 second.
She's at the Alpharetta jail. Are you here for Miss Moore, sir?
Yes, ma'am.
Is she at the Alpharetta jail right now?
Yes, ma'am.
So what am I addressing, Mr. McLean?
That's going to be a not guilty, and I'm going to ask the court to consider a signature bond.
Are you waiving her presence for the bond hearing?
Well, no, I'd like to have her on so that she can participate, answer any questions, but that don't work.
All right. First of all, position 22, Andrea Contricia Moore, she's not present. She's at the Alpharetta jail. Miss Moore is represented by Mr. Michael McLean with the Public Defender's Office, and he's filing a waiver of arraignment. In other words, he's entering a not guilty plea on her behalf, and the case is going to be reset for jail jury. Now, you want to address Vaughn, but she's not present. So I can reset the case. I don't know when she's going to be brought back down, but the safest date I can put her down is February 23rd.
Oh, I'm sorry. I was under the impression that the Alpharetta Jail would have the capabilities of the Atlanta City Jail, but I'm incorrect in the assumption.
I mean, I'm sure they have the capability, but I don't think they were invited today.
Yes. Yes, hold on.
If I can have a breakout with the state on that, I'll ask them a question too.
Okay. All right. Whenever you're ready with your laptop, Mr. McLean, you can do all the breakouts you want.
Okay. Yes, Your
Mr.
Honor.
Howard, are you ready with the competency? I just saw him stroll by.
Give me a few minutes. I'm gonna get on Zoom in another location.
Okay.
Lauren, did you find out what's
I'm
going on?
going on in now.
Mute your screen, courtroom 2. All right, sir, the one titled the K-51 for Miss Moore.
Yes, ma'am.
All right, her attorney has filed a waiver of arraignment and is going to be talking to the prosecutor. You're more than welcome to hang on until we get a status update.
Yes, ma'am. Thank you, Your Honor.
Please mute your screen.
Yes, ma'am.
Ms. Champion, you're going to be getting multiple requests to put different folks in different breakout.
Yes, Your Honor. I already have Mr. McLean and the South Annex in the breakout. And once the South Annex come out, I'll put him in the breakout with Dr. Clarity.
Okay. And
She
whatever
saw
you
that
do,
on.
yeah, just make sure I'm in a breakout with Mr. Walker and
Mr. Howard.
Mr. Howard
Okay.
and Ms. Quisenberry. Who's our social worker today?
I'm not sure. I don't see it. I think they might be in courtroom 2 today, the social worker. I thought I seen Kasha in there with Derek.
Oh, is Kasha there?
Mm-hmm.
She may have to go into the quiet room with Mr. Howard. All right. Dr. Clarity, Mr. McLean is going to be reaching out to speak with you. All right, we'll be in recess until Mr. Derek Howard's ready to go into the breakout. Yes, Dr. Clarity, the attorney will be reaching out to you, so you can either stay on the Zoom or
On her phone. So I just joined the Zoom back.
yeah, they have lots of cases, so you just have to wait until they call you.
Okay, so I'll wait for his call. And should I get back on after lunch?
After lunch, why would you? No, you stay on the Zoom until it's over.
Oh, okay.
All right, thank you.
Thank you.
Hi, Deputy Milton. Oh. All right. So I see Mr. McLean is on the laptop on Mr. Doty's.
You go.
All right. Ms. Champion, please place Mr. McLean in a breakout room. You can dedicate that to like McLean breakout room. And
McClarity.
Dr. Marsha Clarity.
Right, Dr. Marsha Clarity.
And we will
Yes.
place her in the breakout room with Mr. McLean. Oh, sorry, with the Zoom panel that says Angelo Doties. Dr. Clarity and PD Angelo Doties.
Right, this one, that one right there. Very good.
And then Deputy Milton, after Mr. McLean is done with Dr. Clarity, we will place, well, I'll let him call out for South Annex so he can talk to Miss Reese, okay? Any sightings of Mr. Derek Howard? Mr. Walker, can you text?
Well,
me?
he's been in the courtroom. Sometimes we have to duck out into the Zoom session by going to a phone in the car, in the parking lot.
I can
That's
shoot my text, Your Honor.
Okay.
Ian,
Yes.
what do you think about a signature bond for Ms. Moore? Now, did you notice the date of it?
Over there for me.
Would you like to do a breakout session or do you want to do it in open court?
Let's do a breakout.
Okay.
I've got Clarity. I keep saying McClarity. I've got Clarity coming into breakout with me as soon as they can set that up. But if you look at the police report in that Moore case.
Hang on, Mr. McLean. Let's focus on Dr. Clarity.
Sure.
You have to click on join the breakout room on the screen.
Yes, I
Oh,
put Mr. McLean in the breakout room with Dr. Clarity.
Okay, I see mute and I see some dots.
No, they're still in the main Zoom.
No, I moved him over to my breakout room. I don't know why he's not.
Look, Mr. McLean is under the Zoom name Angelo Doties.
Right.
I've moved PD Dotis to breakout room 3 with Dr. McClarity.
All right.
Hold on, let me close out our breakout rooms and redo it.
See, it's still got the, all right. Well,
All right. Welcome, Mr. Howard.
Welcome. Thank you, Judge.
Is Kasha with you or?
She's actually at the jail, so I think courtroom, or is Kia on the line?
Kiana is on the line, on Zoom.
Ms. Burgess is on Zoom?
No.
Okay, then Kasha would need to come in with courtroom 2. They so loud, I don't know. We can go on without, I guess, her being on if we need to. Well, she's at courtroom 2, but.
Do you have her number? Can you text her in the courtroom and let her know that we're going to?
Your Honor, I'll go track her down. I was trying to get her set up on my laptop before I saw that McLean was gonna keep running breakout rooms, but she's back there. Out there, man.
Oh, there's Kasha.
Hey, I'm here. And
But you cannot be in the courtroom. That's the problem because there are too many people. We need to be
So
in a
I'm gonna, wait for Mr. McLean to be done and then I come and request it.
Oh,
Please do
So,
that.
I mean, we may have to go ahead and start, Judge,
Yeah.
with Judge Wells. There is one case, position one, that he's in courtroom two that we're gonna do. It looks like it's gonna be a non-negotiated plea on Mario Bell.
all right. Kasha, we will get back to you, okay?
Okay.
Thank you.
That's all. That's all.
Miss Champion, one more breakout room with Mr. Ian Walker, Derek Howard, and myself, please.
Okay, are we done? Is SAP done?
No, they got a couple of more pleas that they're gonna take.
Okay, it just got real dark and quiet. I just want to make sure.
Okay.
I think.
Judge Law?
Judge Law is in the breakout room, Deputy Milton.
Okay, Miss Champion.
Yes, ma'am.
Do she still need to see Miss Reese?
She's on the competency calendar.
Yeah.
For Miss Reese, position 26 on the regular SAP.
Yes. That was the last one she was doing?
Okay, yes, I think she do because Mr. McLean did not make an announcement before he went into the breakout room with another defendant.
Okay, because the thing is that I have to get these ladies back so I can bring up the other ones for the competency calendar that's going before her.
Because Miss Reese is gonna take a plea, correct?
I believe so.
Yeah, she has to see it in order to take,
Okay.
do the plea.
Okay.
I'm sorry.
No, not a problem. I will definitely make it work.
Okay,
All right, so I'll be back and forth because I'm now doing felony calendar in another area.
okay,
So I'll be back and forth.
okay.
Okay, thank you.
Mhm. Mr. McLean, do you need to also speak to Corey Thornton mom?
Phone, and she's clear.
You can ask her.
She is all in favor of his not being found incompetent and going forward today.
Asked her to put me in the mental health breakout room.
Okay, so
Is there-
Kasha, you need to go into the breakout room with the judge and Derek.
Yes.
Please, thank you.
Okay,
Yeah.
I put you over. Thank you.
I'm keeping on the battery.
Okay.
You don't need to call.
Ms. Champion?
Yes, ma'am.
Okay, I have to go down and get Miss James, Miss Madrano, and Miss Brown.
Okay.
Also, do you know if I need to bring Miss Brittany Fagan?
I'm not quite sure. They haven't made any announcements to me at this time.
Okay, what about Karen Daniels? Were you able to get in touch with Mr. Murphy?
Mr. Murphy hasn't logged on today, so I'm not sure if he's gonna come on or not.
See, because can you call me at 404
Mm-hmm,
865
okay,
8114, please?
okay.
Thank you.
Yeah, that's grand. That's a lower level. I don't know about Levine, but this whole piece is doing it though, man. Like I feel bad for her. We should have changed us.
All right, Deputy Milton.
Judge Deputy Milton went to go pull some of the females inmates.
Okay, Mr. McLean, going back to your SAP calendar on. Ooh, okay, there are a lot of people talking at your screen, so tell me what's going on. Let's start with,
Oh, a bunch of people just came back from grabbing lunch, but they're about to close their door. Hold on.
okay, so you
Hey,
have
Judge
position,
Law.
yes,
Hey, good afternoon, Judge Law. Are we still doing, 'cause we still have two people here for SAP?
I'm going to wrap up SAP real fast, on Mr. McLaren, position 29. Denaji Stevens, what are we doing?
Come on, is that you? Come on, I don't have your three card.
Yeah. Tasha, you might want to.
Have a seat in this green chair.
Oh, he's the one I still need to talk to, Your Honor.
Mr. McLean, you spoke to the grandmother, Dr. Clarity. What are we doing?
Right, we explained that we need to have our social worker, Tasha, talk to the client and determine whether we should go forward today. And so she needs to have a little conversation with him to see where his clarity is.
Okay, are we resetting the case then or just waiting on today?
Waiting on today so far.
Okay,
Now, I did talk to Thornton's mother,
okay,
and she understands the concepts of competency versus mental health things. And she is not opposed to him taking a plea. She said that he is competent in her opinion.
What's your name? Thornton, right?
All right, Corey
And I-
Thornton, okay, whenever you're ready to get back to the jail, we can take the plea.
Okay, and the other thing is,
Thornton.
I need
Yes.
a short breakout room with Mr. Walker so I can discuss that bond in Andrea Moore's situation.
Okay,
I'll be glad to chat. I don't mean to be rude, but the answer is no, Attorney McLean.
I mean, did you read that paragraph where he said he was too drunk to know if he was hurt by anybody?
okay, listen. Miss Moore,
Andrea Moore, right.
Andrea Moore, and that was 22, okay.
And she's stuck up in a place that did not have a thought about getting on Zoom today, apparently.
All
So
right. So Mr. McLean, let's get you into courtroom 2 and we can take the plea. And then I'm going to address position 22 on Moore.
Okay. Thank you.
And, oh, forgot to ask you about, this is Mr. Thornton. We're going to take a plea right now. And then, and as soon, and who's the third person seated on the front bench?
He's the, competency, that's Mr. Bell, that's position 1.
Okay, thank you. Okay, as soon as I'm done with, all right. This is position 32, Corey Thornton. And we're going to resume the plea hearing for Corey Thornton, in which Mr. Thornton was already advised of his rights, advised of his, he was placed under oath. And the state's offer by Ms. Lewis was 12 months to serve 283 days, balance probated, to be on probation, to complete 6 weeks of anger management classes, 40 hours of community service with a nonprofit agency, and have no contact with Erica Ware. Is that correct, Ms. Lewis?
Yes, Your Honor.
All right. And Mr. McLean, after discussing the matter with Ms. Thornton, Mr. Thornton's mother, you are satisfied that Mr. Thornton is able to understand the proceedings and able to make is competent to make a decision as to whether he wants to waive his constitutional rights and enter a guilty plea?
I do believe that he is, Your Honor, and I've always felt that. And I believe that Ms. Thornton, the mother, agrees that as well.
All right. Mr. Thornton, do you, and Mr. McLean, I believe you've already stipulated to the factual basis, venue and ID?
We have.
All right. Mr. Thornton, have you consumed any medication or alcohol recently?
I get married.
Okay. And with the medication you've consumed, are you still able to understand the proceedings so far? Have you been able to understand your attorney? You need to repeat clearly, yes or no? And have you been able to understand, are you satisfied with the services? Is anyone forcing you or inducing you to enter a guilty plea today? I don't understand what you just said.
Oh, that's not.
Mr. Thornton, if you enter a guilty plea to the charge of simple battery domestic violence, you will have to give up your constitutional right to go back to court and have a trial. There will not be a trial before a judge or a jury. You will not have the assistance of an attorney to help you challenge the state's case and its evidence, to examine witnesses, confront your accuser, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? I don't understand your response.
No, she's saying, are you giving up your trial? That's what she's saying. Are you giving up your trial rights in order to go with this instead?
You sure, Doctor?
You want me going back to trial? You won't be on that track again. So is that what you want to do?
Repeat. How do you plead to one count of simple battery family violence? Repeat?
If you're pleading not guilty, we're going to trial later on. That's okay. If that's what you want to do. If you want to try, that's fine. You're entitled to go to trial. If you want to take this to trial, you may. All cases are designed to go to trial unless somebody stops it first. So it's your decision.
Your Honor,
Just 1 minute. All right, Mr. Thornton, how do you plead to 1 count of simple battery domestic violence? All right, so the plea has been rejected. The case will be set for trial. Mr. McLean, do you, I'm going to go ahead and arraign the case. Do you waive a reading of the accusation?
We do so waive a formal reading of the accusation, Your Honor, and I'll be sure to be in touch with the trial court.
Okay. Mr. Thornton, as you've entered a not guilty plea, I just want to advise you that upon your entry of a not guilty plea to the charge of simple battery domestic violence, the case will be set for a jail jury calendar. At the time of the trial, you will be represented by counsel and you are presumed innocent of the charge when at the time of the trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. If the prosecutor succeeds and overcomes your legal presumption of innocence, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. So this case is now arraigned pursuant to your not guilty plea, and the case is reset for jail jury. Thank you. Yes, Mr. Thornton, what did you want to ask me? Ms. Thornton, did you have a question?
yes, in terms of his bond, is he able to do a signature bond?
That's something his attorney would have to argue for.
What I'm going to do is point out that if he's got 280 something days already done, Your Honor, and this is 1 count of simple battery family violence, the jail portion, the part that affects his actual liberty, should be over with. He's not had bad behavior in jail. And if he had pled guilty or had a jury found him guilty in a trial, he would have been released at the 183-day mark because of good behavior. It's not really right. Yeah.
Mr. Walker or Ms. Lewis, do you have a response before I chime in?
One moment, Your Honor. Just so I get some clarity, PD McLean, are you asking that, what is your ask here? I'm sorry.
Mr. McLean is asking if the matter can be, if the bond can be reduced or modified to a signature bond considering the length of time that he's currently been incarcerated, which is 283 days.
The state would have no objection to that.
Thank you.
All right, his bond is going to be modified. And Mr. McLean, you'll send us a proposed order?
Yes, Your Honor. Thank you.
Okay, this is the simple battery domestic violence from May 8th, 2022. And bond's going to be modified to a $2,500 signature bond through pretrial services. He'll report to pretrial once a month and have no contact with the alleged victim, Erica Ware. No weapons, no illegal drugs, and no alcohol. Make sure that he maintains a current address and contact information with the court at all times, and he will be summoned for trial. Thank you.
You know, very quickly, at one point, I believe he was told to stay away from 2190 Verbena. At that time, back in the day when this was occurring, he and his cousin Erica lived at the same address, it was said in the police report. I understand that's no longer true, and probably his mom can be the most accurate person in the world about who's living where.
Yes.
Who's living where?
Ms. Thornton, does the Erica Ware still live at Verbena Street?
No, ma'am, she resides in Noonan, Georgia.
All right, he can return to the incident location if you want to put that Verbena Street location, as long as the victim does not reside there.
Thank you.
Thank you, Your Honor. Thank
All
you.
right. Moving on, this is reset. This is further notice for trial now, not jail jury. It's further notice for trial. It's a signature bond. Thank you. All right. Francois, we can remove Mr. Thornton. Position number 1 on the competency calendar. All right. All right, the gentleman who is calling about Miss Moore's case, what's your phone number? You need to unmute. You need to unmute.
It's 404-573-7845.
And what's your name?
Ernest Lewis.
Ernest?
Lewis.
Spell the last name?
Lewis.
Oh, Lewis, Lewis. Okay. Mr. McLean, did you get that number?
Yes, I did, Your Honor. This is the alleged victim in the case.
All right. Okay, Ms. Champion, can you place myself, courtroom 2, Mr. Derek Howard, and Mr. Ian Walker in a breakout, please?
Your Honor, we can do that, but Mr. Bell was found competent, if that's what this is about.
Oh, okay. I'm so sorry. I didn't. Okay, Mr. Howard, is this the one where Mr. Bell on our competency calendar is now deemed competent?
That is correct, Judge.
All right, and what are we doing with this case today?
It's going to be a non-negotiated plea, Your Honor.
You have the plea paperwork?
Yes, Judge. It's not filled out, but yes.
All right. Mr. Walker, are we ready to proceed?
Absolutely, Your Honor.
Okay, thank you.
So- I'm sorry, go ahead.
Oh, okay. This is State versus Mario, Mareio, last name Bell, common spelling, accused of harassing communications from November 2nd, 2021. Accusation number 23 CR 000166B. Mr. Bell was originally on the competency calendar, but since he's been deemed competent, he is ready to move forward on the regular SAP calendar, and the defense is seeking a non-negotiated plea hearing. So, Mr. Bell, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is going to be Mr. Derek Howard. Do you see Mr. Howard on the screen?
Yes, ma'am.
Oh, you see him?
Yes, ma'am.
Thank you. All right. This is going to be a non-negotiated plea, which means that Mr. Walker, who represents the prosecution, is going to give me the recommended sentence to accept a guilty plea. And then your attorney, Mr. Howard, is going to give me an alternative recommendation, and I will decide which recommendation I will select, keeping in mind that I have a right to disregard the plea and schedule the case for trial. So, Mr. Walker, what's the recommendation?
The state's recommendation is 12 months to serve 180 days. The defendant has served, I believe, 37 days in custody, so he will get credit for that time. Balance probated, no further contact with the victim, ADA Ayana Young, and a mental health eval and necessary treatment. I understand that a competency evaluation has been done. He was found competent, but we still are asking for a mental health eval, as that is something separate in nature than competency for trial.
It's semantics, but is the state open to a BHET instead?
That's fine.
Okay.
And to give you his criminal history, I have a 2017 burglary conviction, a 2016 robbery conviction, 2019 shoplifting conviction, 2021 felony terroristic threats conviction, where he was sentenced to 5 years, served 2. And then I have another 2021 interference with government property conviction out of Fulton County. It's important to note that 2021 conviction for felony terroristic threats, because 2 days after he was released, he actually showed up to the district attorney's office in an effort to see the victim in this case. To give you some background on this case, from the dates of November the 2nd of 2021 to November 17th of 2021, the defendant contacted the victim, ADA Ayana Young, approximately 100 times via telephone and social media. She asked the defendant to stop calling her. She could not assist him in his open 2 pending felony cases at that time. He continued to call every day, multiple times. Like I said, it totaled to be 100 phone calls in total, and he also contacted her via social media. When he was sentenced on the felony terroristic threats, he was released on November the 15th of 2021. 2 days later, he showed up to the DA's office, still attempting to get access to Ms. Young. We do have contact with Ms. Young. She is afraid for her safety ever since this incident occurred. She has had to be escorted by the Fulton County deputies to her car when she leaves the office. And the state also is particularly concerned because as of recently, the defendant has been reaching out to one of the ASGs in our office, and he has now turned to her and has been harassing ASG Heather Tucker.
Objection.
He has,
those charges are not before the court. There hasn't
but
been any charges
it's
brought in
relevant
relation to
because
that.
in this case, he was
So,
Hang
harassing.
on, hang on, folks.
In this
Okay.
case, he was harassing her ADA. And
Okay.
now, in this case also, he has now reached out to our SG and has continuously contacted her, even though she told him she was not the SG handling his case.
All
So
right,
there is some
Mr.
concern.
All right, Mr. Howard, what's your objection to that comment about the ASG?
Well, Judge, I mean, it's an uncharged speculative allegation that we have there hasn't been any charges filed or anything related to that. And we would ask, for that to be considered at this stage, we don't believe is appropriate. And I can respond more fully to our request for our jail time if you want me to do that at this time, Judge.
Let me see, Mr. Walker, have you concluded?
For right now, I'll respond if necessary.
All right. Mr. Howard?
Yes, Judge. And Mr. Bell acknowledges and is willing to resolve his case today. He acknowledges that he does not and should not continue to contact ADA Young. However, just as a matter of context, Judge, he indicates that he and Ms. Young have known each other for many years, grew up in the same neighborhood. He knows her family knows his family. They've had dealings over the years, and he indicates that part of her motivation for this is because of some of the people that they both know that are involved in even some of the more high profile cases, that it's in her best interest to appear that she has no affiliation or any type of affiliation with him or other persons that are involved in high profile cases. But he indicates that he understands that he cannot continue to contact her. We've had that conversation. He acknowledges that he wants to resolve the case today. However, we would ask the court to sentence him to 12 months served 90 days. Mr. Bell has been continuously incarcerated since November 21st of 2021 on one of the cases that the state mentioned in Clayton County. I called Clayton County and spoke with Officer Elder there and verified that he was there from November 21st of 2021 until he was transported here on, I believe, January the 10th of 2023. So, I mean, in this incident is an allegation from, November of 2021, Judge. So since that time, I don't believe there's an allegation he's made any contact with Ms. Young since his arrest in November of 2021. And given that he has been in custody for such an extended period of time, and he's going to need to put his life back together, find some type of employment to be able to reintegrate himself into society, we'd ask the court to sentence him to 90 days as opposed to the 180 days that the state is requesting in this case, Judge, and he's fine with no contact. He hasn't had any contact for more than a year and a half or so, and he won't continue to have contact with her. So we would ask the court to consider 90 days.
The state's response, if I could, going back to that 2021 conviction for felony terroristic threats, the victim in that case was a detention officer at the jail that he threatened to shoot in the head and kill. So this defendant has a history with threatening government officials, if you will. According to the defendant, that's the reason why he was attempting to contact the victim. However, that doesn't make sense because after he was already convicted, served his sentence, and was released, he still came to the DA's office, which I would consider escalation, attempting to see the victim. So he could not have been trying to contact her about a case that was at that time closed.
And there's that
And then
speculation.
any time that he served in Clayton County for his felony drug possession case has nothing to do with the time that he should serve on this matter.
Mr. Howard, why am I applying his jail time from his other arrests to this case?
We're not asking you to give him credit for that, Judge. We asked you to give him credit for the time he served in Fulton County Jail.
No, but
My only point
for
is-
what case? That's what I'm trying to figure out. For
Well,
which
he's been in the Fulton County Jail for this case. 37 days he served for this.
Well,
case.
yeah, that's what the state has said. 180 days, credit 37 days.
Right. And I'm asking the court to give him credit for 37 days, but I'm asking for a sentence of 90 days as opposed to
Oh, I see.
180 days. Right.
Okay, understood. Understood. Okay. Anything else, Mr. Howard?
No, Judge. And my only point when mentioning the other jail time was just to indicate that he has been in custody for an extended period of time, and it has, ultimately, this offense is from November of 2021, so it's more than a year old as well. So we would just ask the court to take that into account and consider a 90-day sentence.
Deputy Francois or Deputy Norris, if you could unmute courtroom 2. Mr. Bell, you have a right to remain silent about the facts of the case. And if you choose to waive your right to remain silent and you want to address the court, please keep in mind that anything you say can and will be used against you in the treatment of this case. So would you like to remain silent or would you like to waive your right to remain silent?
No, man, I don't want to remain silent. I want to speak up, man.
Well, Judge, I'm not sure what you're asking my client, but if
He's been raising his hand throughout the entire argument, so
well, Mr. Bell, you don't need to respond to the.
I want to, may I respond to the, may I respond, Mr. Judge Law?
I would advise you not to, Mr. Bell. It's your.
I'm all right, sir. Thank you, sir. I'm surely all right.
I know you think it's gonna help you, but this is being recorded. If your case ultimately ends up going to trial, anything you say now can be used against you. I advise you to not make any open court statements. You have an attorney for a reason. So that's my advice to you.
Can I speak up, ma'am?
Sir, the decision to say something is entirely up to you, but you should listen to your attorney because he's giving you very good advice.
I understand, man. I'll be careful with the words I say in this court.
I'm sorry, what do you say?
I said I want to speak. I want to speak up. I want to speak up.
Are you waiving your right to remain silent?
Yes, ma'am.
All right, Mr. Howard, your client's made a decision. Go ahead.
Yes, ma'am. I want to first address the him saying about since I have a terroristic threats that's why I came to the office. First of all, what reason how I got in contact with Miss Ayana Young, me and Ayana Young are childhood friends. We grew up in Ponte Ridge together. Her mother name is Miss Tarisha. She got 2 baby brothers named Quasi and Drake, who they are associated with Saron Lee. Nietzsche is a rapper, and Gunna, who is a rapper. How I got in contact with her, I always knew Ayana growing up. When I found out she worked in the DA office, matter of fact, she went to college in Florida. So I always been knowing she been going to school to do what she's doing right now. I just tried to reach out to her because the judge had sentenced me to a program. But I was in there for a probation. They sentenced me to a program. So I was trying to get Ayana to get the judge to just release me. Cause you know how y'all, in my mind, I was like, since she was in the DA office, she's cool with them people, they can look out for me. So she considered that, you know what I'm saying? She considered that. She said she'll try to.
Mr. Bell, did she ever agree to meet with you?
Yes, ma'am. She actually gave me the reason why I was able to contact her on the street, because she gave me her county number. We was on good terms. She gave me her county number, and I asked her, can I see her? And she said, yes, on Wednesday I can come see her.
Now you're gonna stop, you're gonna stop right there. Okay, you're gonna stop right there. Since there is an issue of whether the alleged victim agreed to meet Mr. Bell, or whether Mr. Bell has a totally different version of events, it's clear that this is not a proper venue to enter into a plea. I'm not taking a plea today, unless of course you want to, but Mr. Bell, if you are absolutely certain that you had a right to contact Ms. Young, then you should go to trial and not give up your right to a trial.
I mean, man, I've been locked up since. The reason why I'm trying to resolve the case, I feel like it's a petty case.
I'm not taking the plea. Based on what you've told me, you have a bona fide belief that you were not harassing Ms. Young, and you have a bona fide belief that you had the right to contact Ms. Young. Of course, Ms. Young has a totally different perspective, and that's an issue for the trier of fact, like a trial or a judge to decide. I'm not prepared to take the plea today.
Can you modify my bond? May I have a bond modified?
All right, next question. Mr. Howard, as this case has not been arraigned.
You're asking me if it's been arraigned, Judge?
No, it's not.
Right, it
He
has
had a
not.
bond order for $10,000, a good bond set on January 11th, 2023, with no further contact with Iyanna Young, and to stay away from Fulton County unless on official business. And I'm going to define the official business shortly. But do you want to pursue a hearing on a bond modification, or would you like to do it another day?
No, Judge, we had prepared to argue that as well. We would ask that the bond be modified to an amount that might be reasonable for his family to make bond for him. He is a lifelong Georgia resident, as he has articulated. He attended high school right here in the Metro Atlanta area. He has family that still lives here in the Metro Atlanta area. Before he was arrested, he was working at a warehouse, STG Logistics, as a warehouse worker until he was arrested for the case that was mentioned earlier in Clayton County. So Judge, he has every intent, if he's required to come back to court for any court dates, to do that. I didn't hear any failure to appears in his history or anything to indicate he's unlikely to return to court. So we would ask the court to reduce that bond to $2,000 from the $10,000 surety that is currently set at, which would still, he still have to make a bond. But at this stage, Judge, we'd ask the court, given for all the reasons we've stated previously, to reduce the bond to $2,000 so that his family could potentially, that'll be a stretch as well, Judge, but to a lesser bond amount so that he can potentially answer these charges outside of the Fulton County Jail.
Mr. Walker?
Yes, Your Honor. Again, this defendant has 43 cycles. I'm not going to go through each cycle.
No, I'm already familiar with his GCIC. Just give
Right.
me your bond recommendation.
And what I want to add to it, because actually his felony probation was here in Fulton County was revoked last month, in addition to what I cited earlier. But no circumstance has been changed. The defendant has intimidated the victim. We do have contact, as I stated. The Fulton County deputies now have to escort her to her car every day. He has now been harassing ASG Heather Tucker, which is concerning because ASG Heather Tucker was never assigned to this case. So how he got a hold of her and has been calling her and leaving her voicemails every day repeatedly is a concern. And now she is somewhat concerned for her safety. As I stated earlier, the 2021 conviction for felony terroristic threat, that was for threatening to kill another government official. So we feel as though a $10,000 surety bond is more than reasonable based on his criminal history and the facts of this case.
All right. Bond is reduced to $7,500. It is a surety bond. No further contact with Iana Young to stay 200 yards away from her, not to communicate with her in person, not through a third party, not through a phone, a computer, or any social media. No device. He's, with regards to Ms. Tucker, of course, if the contact persists, she would have to reach out to the court to receive a protective order, since I do not have a criminal case with regards to ASG Tucker. And ASG Tucker's position is not in any way remotely connected to this case. He's to stay away 200 yards away from the Fulton County Courthouse, especially from the offices of the Fulton County District Attorney's Office and the Fulton County Solicitor General's Office, unless he has a written notice that he has an appointment with either the District Attorney's Office or with the Solicitor General's Office. There has to be a written notice that he has an appointment, and the written notice must be generated by the District Attorney's Office or by the Solicitor General's Office. He cannot sua sponte on his own go to those offices unless he has a written notice of an appointment. He is not to enter the Fulton County Courthouse unless he's got an official business, which will include a written court date to appear in a specific courtroom for a specific case, or if he has business to conduct in any of the government offices, such as the real estate.
Hey, Ms. Livingston Milton. Patricia Kraft, she's the
I'm
only
sorry,
one.
Deputy Milton, you need, yeah, okay, that's okay. Sorry, unless he has an official business, like say, for example, he wants to get a marriage license, or he has business in the real estate deed room, something to that effect. But he must prove that he has official business to conduct if he's confronted by law enforcement. All right, no illegal drugs, no weapons, no alcohol, and that concludes the bond. Mr. Howard, you will present that bond order? I'll do it.
I need some of those terms repeated, Judge. If you can
I
help
got
me
it.
to-
I got it.
You got it? Okay,
Yes, sir.
all right.
Okay, yes, Mr. Bell, what is your question?
I want to represent myself, man. I don't even want no attorney. I represent myself at trial.
All right.
And the reason why I attacked Ms. Tucker because the previous court dates I have, the first appearance, the previous court dates I have, I told the judge I wanted to represent myself. So I should have been representing myself. I contacted Ms. Tucker because when I called the solicitor office, they told me she was the one on my case. I called her, she told me she was on sick leave and that I need to contact her supervisor. So
Okay.
so then I've been trying to contact the supervisor and work out a plea, but I was never able to. Then the competency thing came up with him. You know what I'm saying?
Mr. Bell, I'm going to arraign your case and you can enter a plea of not guilty. And that way we will start the process of putting the case on the trial calendar.
Yeah, and
Do
I
you
want
want me, you have to listen very carefully. Do you want me to read the accusation or do you want to waive a reading of the accusation?
I want a copy of the accusation.
Do you want me to read it at the present time?
Can I have a copy of it and I can just read it myself?
I can send a copy. Miss Grace, can you
And
see?
please don't give me no attorney without my consent. No, I've been asking for attorney since first appearance. I should never.
If you interrupt me one more time,
But you gonna give me 12 months?
if you interrupt me one more time, I'm going to go back to the original bond order. Okay, now, with regards to the accusation, let me go ahead and all right, I'm going to have it sent to my litigation manager who will send it to, can you send it to, do you know Francois's email or? Francois or Deputy Norris, who's in the courtroom, can we send it to your email so you can print it and give copy of it to Mr. Bell? Courtroom 2?
Please
Yeah,
follow
okay,
me.
Your Honor.
for trying to make for these.
All right, let me go ahead and Ms. Grace is going to, if you can put your email, Deputy Francois, in the chat to, you can put it to Melissa Grace. Do you see Melissa Grace on the Zoom?
I'll send her an email. And don't give me no attorney.
Deputy Norris gonna send an
I write up my own motion.
So now with regards to the accusation, do you want me to read it or do you want to just get a copy?
She's a gang member of YSL Slime, who y'all prosecuting.
Okay. So State of Georgia versus Maria Bell, 23 CR 0000166B has been accused of harassing communications. Mr. Bell was asked whether I can read the accusation or he requested instead a copy of the accusation, and we're in the process of emailing him a copy of the accusation. The accusation is a misdemeanor offense, and upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecutor would have the complete burden to prove the charge against you beyond a reasonable doubt. If the state succeeds, the defendant could be convicted of the offense and be sentenced to up to a year in prison and or up to $1,000 fine. Given this information, how do you plead, Mr. Bell?
Man, I don't want to plead nothing, man. Fuck y'all, man.
All right, we will deem that to be a not. All right, thank you. The case is further notice for trial. I think we're going to mute the courtroom too until they get a hold of the situation.
Your Honor?
Yes?
Okay, I have 1 o'clock court that I need to attend to. Do I need to bring them up?
I don't know who is going to be brought up. Let me see.
I'll be right back.
And Mr. Yeah, that's fine.
Your Honor.
Yeah.
Officer Duffy on 4 North. I have an announcement for competency 17, 18, and 19.
Mr. Schoenhofer, yeah?
Yes, he refused to put on his uniform and refused to be on camera. So the deputy actually put him back up, and I guess we got to reset him because he refused to put on his clothes.
Okay. Mr. Howard, that's the case that we've reset to SAP for February 23rd. No, sorry, competency, February 23rd.
Yes, Judge.
All right, please let Mr. Schoenhofer know that we hope he can join us on February 23rd.
Yes, ma'am. Thank you.
All right, thank you. Moving on, Deputy Milton, who do you have ready? Do you have any of Mr. McLean's cases ready? Because that's the only ones I've got left. Mr. McLean, the cases at the South Annex?
Okay, I have Monica Brown, position number 2.
Oh, that's on the competency calendar.
Yeah.
Okay, Monica Brown on position number 2. We're going to issue an order. Is she appearing?
But the thing is that I have not gone and get them yet.
Okay, that's okay. That case is going to be reset to March 2nd. And I'm going to issue an order requiring her to speak to Mr. Howard, the PD, and to comply with her medication. But we will see her on March 2nd.
Okay. The next, position 14, Angela James.
Angela James is, we're going to do a release order for March 2nd. And Mr. Howard is going to submit the proposed release order.
And actually, Judge, I think it was February 23rd.
Oh, was it February 23rd? Okay.
But I need, is her daughter on the line? We needed to confirm that she would be able to be, I think she is Miss Williams. I don't know if we can break out for that quickly, Judge.
Sydney Williams is on Zoom. Could you start your video, please?
Yes.
Yeah, March 24th, excuse me.
Sorry, I just finished working out, so I have a hoodie on.
While we're waiting on Miss Williams, who else is on your list, Deputy Milton?
Position 15, Medrano.
Madreno is, there's going to be a release order for him to, or for her, excuse me,
Yeah,
to attend PAD on February 23rd.
yes, February 23rd, Judge.
Sorry, it's not letting me turn the video on.
You need to figure it out. I can't allow this
Okay.
unless you can. All right,
I can
next,
come back in.
go ahead. Next on your list.
All right. Karen Daniels, I've been having issues with trying to get in touch with her attorney.
Okay, Karen Daniels' attorney is Dennis Murphy.
Right. He's
And
not,
her, yeah, her case is going back to Judge Morrison. So she may be transported to Judge Morrison's courtroom if they're doing in person.
Judge Morrison in person.
Yeah.
Do you
That's
have,
position 4 and 5.
right, do you by any chance have a date for that or an attorney that,
Mr. Howard, did you say April 23rd on Karen Daniels?
No, I didn't, that's not my.
I don't
person
have
to make
a,
an
I don't
announcement.
have a date for Karen Daniels because that would be Judge Morrison's calendar.
I think
Okay.
Mr. Jordan spoke to her case.
I think I could double check, but I think Mr. Jordan might have said April 23rd. Yeah,
April 23rd, okay.
I
Oh.
think, let me double check.
for a court date?
You'll be notified, Ms. Milton, just, I mean, we don't have a court date, that's
But-
today. But
I
she'll
have
get,
Okay, because I have to let her know something because they've been calling.
we don't have a court date today.
Just give
You
me
can
one
tell her
second
April.
to-
You can give me that April 23rd.
Just hold, Deputy Milton. We'll see if Mr. Walker can give you something. Okay, who else besides Karen Daniels?
Brittany Fig in position 9, she knows that she's supposed to come to court. You have any information I can give her?
Yes, it's
So-
going to be reset to SAP calendar on March 2nd. She's been deemed competent. And the public defense attorney will speak to her at that calendar, March 2nd at 9 a.m.
Okay,
Yes.
all right. So I don't have to bring any of these ladies around. I can just give them the information, right?
Please, thank you.
Yes.
Thank you so
And
much.
I'm sorry, Deputy Miller, there's no court date.
Okay.
Okay.
It'll be before Judge Morrison, and we do not have a court date. It will be anytime in March or April. And she would need to reach out to, or you would need to reach out to Dennis Murphy to confer anything else. Okay, sorry, that's all we have.
Okay.
Okay, Mr. McLean, have you spoken to your client, Miss Reese?
Yes, Your Honor. I explained to her that today, I explained to her the nature of what SAP is about, and she was bringing up an issue about needing certain social work, and I told her, you know, we couldn't accomplish all the social work today, and that she would receive a social work visit in the future. She was talking about, you know, a program. She had in mind a particular program, and I said, we can't really do that program.
So we are not taking, are we resetting her to another SAP calendar?
That would be fine. I'd make it a couple of weeks.
Reset March 2nd, SAP for position 26. The other one was position 27 and 28. And this is Samantha Solano, who's at the Alpharetta Jail. I
Right.
can reset that for March 2nd, pending their transportation to this jail.
If we can do that quicker, Your Honor, because I believe she was negotiated plea, was she not?
Yes, February 23rd.
Yes, right, as soon as possible, right.
Okay, 27 and 28 is February 23rd. That leaves us with Miss Moore. Have you spoken to Ernest Lewis?
Mr. Lewis was on, but I don't see him on there now. Now I see a Patricia Lewis. I don't know if,
Okay.
I have no idea. I have.
Alpharetta Jail has not appeared at all during the entire SAP calendar.
Hmm.
Okay, and I can, and he gave us his phone number. Ready? 404-573-7845. His name is Ernest Lewis. And this case is going to be reset to the SAP calendar next week, February 23rd. Hopefully, she would be released and transported here.
The 573, what area code was that, Your Honor?
404-573-7845.
Thank you.
All right. Deputy Milton, thank you so much. I've given you 5 minutes to make it to your next court. Okay. Yes, ma'am.
One more question. Oh, that has been moved to 2 o'clock.
Oh, okay.
But I have Brittany Gibson, position 11.
Okay, before I get back to the competence, is it on the regular calendar?
No, she's on the competency calendar.
Okay, give me a moment. I'll get back to that.
Okay,
But position 29, Denaji Stevens is, you spoke to Dr. McClarity, Mr. McLean?
Yes, and also following that, we established that we needed to have the social worker speak with him. And we feel that it is best to go ahead and see if we can go ahead and accomplish the plea today. Mr. Stevens feels comfortable doing that.
All right. Okay, so that is not for Deputy Milton. Deputy Milton is position 19 on the competency calendar, and that was Schoenhofer, Deputy Milton?
No, position 11, Brittany.
Oh, 11, Gibson. Gibson is reset to March 2nd.
Okay. So let me get clarity for the ones that's going to be released. Angela James is going to be released on February 23rd. And Madreno, February 23rd, to the PAD program.
Correct.
Okay, thank you so much. I will go and let them know now.
Okay.
Abby, it's you.
Yeah, Mr. Howard, Ms. Williams is on the video. Did you want to ask anything?
Yes, Ms. Williams, good afternoon. I got your message regarding being able to return. Can we go, do we need to go? Are you able to pick her up to take her wherever she needs to go on? Because we would have her released to you, and then we know that there's going to be a housing element that she's going to stay somewhere other than with you. But we would need you to pick her up on would next Wednesday work for you to pick her up from the jail?
Because I wouldn't be able to come up there until like Friday. I can try to get up there next Wednesday to pick her up. Yeah.
We need a specific date because that's what's going to go in the order.
Right.
She's got to be picked up on February 23rd by and released to whom?
Okay. I've never done this before, so I didn't even know. Friday. Friday is next
Okay.
Friday.
So it'll be the
she's saying
24th.
release date of February 24th.
Any particular time, Ms. Williams, what would be the best time?
Early morning, in the morning.
Okay, we'll say 10 a.m.
Yes, that works.
Okay, all right. And if you know how to use the chat, I think we have it. You could send me your phone number in the chat to me, Derek Howard.
Okay.
So that we can put it on the order because they'll contact you. Yeah.
One on the competency.
Okay.
So this is for Angela James, February
Yes.
24th.
But I do have a question. She's being released on like what terms? Is the case closed or?
No, the case isn't closed at this point. We're actually going to revisit it on March the 2nd, just to kind of talk about kind of what the next step is with the case. But at this point, it's not closed. No.
Okay.
March 2nd, Thursday.
Would she have to be present for that court date, Your Honor?
No,
No.
because she will be picked up by Miss Sydney Williams on Friday, February 24th at 10 a.m. from the Fulton County Jail. So,
Okay.
Mr. Howard, make sure you designate the correct location where she has to be picked up, because she's at the South Annex, not at the Wright Street Jail.
Well, she'll be picked up from Wright Street, Judge. She has to be released from Wright Street. But if Ms. Williams, if she sends me her phone number, I can call her and fill her in.
Yeah, because I don't know if she's gonna show up March 2nd.
Use the chat feature on your phone device to contact Mr. Derek Howard if you want to put your phone number.
Okay, so I'll do that.
All right.
All right, thank you.
Thank you, Ms. Williams. You're free to go.
So she's gonna be released.
All right. Thank you, Your Honor. I'll see you next time.
All right, take care. Be
Bye.
safe.
And what date, June?
Who?
Ms. James.
Ms. James is going to be Friday, February 24th at 10 a.m. Okay. Position 1 on the competency calendar, what are we doing? The plea?
No, Judge, I think you
That
already
was
decided
Mr.
what was
Bell.
happening with that.
Oh, that was Mr. Bell. That was Mr. Bell. That's been arraigned and further notice for trial, jail jury. Okay.
And Judge, he's proceeding, he's electing to proceed pro se is my understanding, correct?
That is my understanding. He was very adamant about wanting to represent himself. So that was what I heard. And so we're going to move on to Mr. McLean's plea on Mr. Stevens. Who's on the jail court iPhone? Who's that?
Position 3 on the company. Mr.
Oh.
K.
Oh,
Mr. Cade.
Yes, yes, Judge. And
All
Judge,
right,
that was- Go
Mr.
ahead.
Cade, you're represented by Mr. Derek Howard. Mr. Howard, do you want to let him know he's got a
Yes.
release order?
Yes, Mr. Cade, as we had discussed, we're gonna ask that you be released. I tried to deal with East Point. I'm not able to get any movement on that, so you're probably gonna go to East Point to deal with that. But after that, you're gonna be with your mom, because I already, you can stay with her. And we set you up an appointment on the 27th for you to have an outpatient appointment, once you get out. So
yeah,
you're
that's what I'm
gonna
saying. I got my phone. You know what I'm saying? I got to make a point. Call my mom.
Yeah, we already made the
Tell me.
appointment for you.
Right
We
now.
already made the appointment. Right, we already made the appointment. I'll give you the details. I'll come see you and give you the details, but
Man, I can waste him off somewhere, bro.
You can do all that.
what was that?
You heard what?
Yeah.
Oh, you said your name, Paul Bartel, right?
No. Paul is another attorney in the office. I'm Derek
Okay.
Howard. I came to see you at the jail, remember?
Yeah, 2 weeks ago, my attorney said I ain't got time to serve for a criminal trip. All I'm saying, really.
Okay, well, you're gonna get out, but you gotta go to East Point.
Eat one, okay.
Because of that hole we talked about.
That's what I'm saying. Like,
I can't fix that.
I got to get my clothes properly, my groundhog pan that I got from City Girl. Stay fresh and all that name brand clothes.
Yeah, they're gonna send your property with you. Wherever you go, they're gonna take your property over there with you.
All right, thank you. That concludes this case. Moving on.
Casa shoe. That's all I told my grandma.
Okay, thank you.
Oh.
As officer, we concluded with Mr. Cade. Thank you. 23 CR 00006, excuse me, 0000674C. Danaji Jaheem Stevens, we've waived sounding on the charge. Ms. Lewis is the prosecutor. Mr. Stevens has been placed under oath. I had Dr. McClarity, Marsha Clarity, who was is the defendant's grandmother. And after we were halfway through the plea hearing, Dr. Clarity raised the issue of his competence, but I believe Public Defense Counsel, Mr. McLean, has been in conference with Dr. Clarity. Mr. McLean, let me know what is the status right now.
We feel that he is competent and wish to go forward with the plea.
I'm not sure if Mr. Stevens is ready to address the plea. He seems to be grooming himself. Are you ready?
Yes, ma'am.
All right. All right. He's already been placed under oath. Ms. Lewis, again, what was the plea recommendation?
Yes, Your Honor. We're actually revoking the earlier plea recommendation, and the state's recommendation is 12 months to serve.
Mr. McLean, what would you like to do?
Your Honor, let's see, let me turn to the right spot here. Okay. I'm sorry. I had turned the page. There we go. Your Honor, we feel that 14 days that he's been in jail on this charge against 28 days of a sentence, which would amount to time served on the jail portion with no extra days, would be the correct solution. He has agreed to go get an evaluation, an SDET. I've told him how expensive that can be. He intends to apply for benefits, and he's got to find some kind of way to afford that within a reasonable period of time. We know the court doesn't expect him to come up with $1,000 or whatever it's going to cost immediately. But he understands what he's charged with. He understands that it had to do with exposing too much of his body in public. And he says that he understands that if you look at the last few years, he didn't do that. This day was an outlier. This day was a bad day, and he intends to behave in a manner which is consistent with public decency and not shock anybody in that way. So he wants to get help. And we've talked to him about if your grandmother or anybody in your family takes you to a doctor, what are you going to do? And we talked about what's involved. And he's ready to address the court about what he's going to do if somebody would like to take him to a doctor because he would like to try out the meds and see if he can get even more stable. But he is determined even now not to repeat the behavior of that day.
So the defense is not going to move forward with any kind of plea today. The plea offer has been modified to 12 months to serve.
Well, I actually would like to make this an unnegotiated plea, Your Honor.
A non-negotiated plea.
Right.
Okay. All right. So with the non-negotiated plea, Ms. Lewis, would you like to recite the alleged facts of the case?
Yes, Your Honor.
GCIC.
Yes, Your Honor. So on February 1st, 2023, officers responded to 7490 Old National Highway, which is the Young Leaders Academy, which is a daycare, on a public indecency call, and they met with Ebony Wilkes, who is the owner of that location. Wilkins stated that Mr. Stevens took off his clothes and exposed himself in front of the daycare center. As a result, the children began screaming, and they are now traumatized. We were able to speak with Ms. Wilkins, and she says she's seen Mr. Stevens around this location several times, speaking to himself. And one of the other workers at this location is a Miss Megan Bryant, who believes that Ms. Stevens likes him, which is the reason why he exposed himself in front of the children. So for this reason, the state feels this is really egregious, especially because this was in front of daycare age children, which is why we recommend the 12 months to serve, Your Honor. And let me see if I see anything in this GCI. One moment, ma'am.
This was on a Wednesday at around noon, according to the warrant. Was the daycare still open for business?
Yes, ma'am. There were children there, and the children witnessed this. Here we go.
All right. Anything else?
I was trying to pull up his history really quickly.
Your Honor, briefly, the state just would like to put on the record its concern with the competency of the defendant after speaking with his grandmother, who stated that he has conversations with himself, which is also mentioned in the report. And then when he was interviewed by the officer, he told the officer he did what he did because he had an itch. That simply just doesn't make sense. So I do want to put on the record that the state is requesting a competency evaluation. Of course, we can't force the court to order such, but that is our first request, and the court is not willing to do so. Obviously, we'll just continue with the non-negotiated plea.
Anything else, Ms. Lewis?
No, Your Honor. The only other charge I'm seeing here is a 2022 theft by shoplifting,
I noticed that he's got a hold out of South Fulton.
and that's for that charge.
The same charge? Okay.
Yes, ma'am. Nothing further.
All right. Mr. McLean.
Did you want to address the court directly and tell the judge what your intentions are with regard to medications?
No, ma'am. No, sir.
You want to tell the judge what your intentions are with regard to public behavior?
Well, I didn't have any control, so
On that day,
yes, sir.
what's the future going to have for you? In terms of your behavior in public, what's the future going to have for you?
Just to do right and serve the consequences.
Why do you feel that you can do right in the future in public?
I would say I feel I can't control how I act. So whether that's me end up being in 1 or 2 dead or in jail.
I'm sorry, Mr. McLean, I can understand your question. I cannot understand his response. It's very muffled.
You gotta speak up loud.
Well, he asked me, what I'm going to do as far as the future. You know, I'm not sure what I'm going to do as far as the future. Anything besides that, I'm okay with whatever's going on here, and I understand.
Okay. Anything else, Mr. McLean?
That's it, Your Honor.
Your Honor, I have to chime in one last time. I'm not convinced that the defendant understands or appreciates what's occurring. He just said he's not certain what he's going to do as far as the future. So if he's not sure what he's going to do as far as the future, I'm not sure how he could agree to the terms of the plea offer. So again, I would just like to put that on the record.
Thank you, Mr. Walker. Mr. Stevens, this is a plea hearing where if you want to accept the recommendation of the prosecutor, or if I accept the recommendation of your attorney, he's not given me one yet, by the way.
Well, yes, Your Honor, the 28 days to serve on the 12 months probation with credit for 14 days time served in SDET.
Okay, which
Which
is
was-
the original, which was the original plea.
Correct, it was fine a bit ago, so yes.
Okay, understood. Mr. Stevens, your attorney is asking me to let you be released from the jail, be placed on probation, and be monitored. The prosecution is asking me that you serve at least 6 months in jail. Do you understand? I need you to say yes or no, whether you understand what I'm saying.
Yes.
All right. I have to make a decision based on the allegations. In other words, what the warrant said you allegedly did at the daycare center on February 1st, 2023 at noon. And whether those alleged actions violate the law, well, you've already got a warrant, so it's already a violation of law being alleged. And whether the recommendation, whether from the state or the defense, justifies the alleged violation. In other words, is it sufficient that you stay in jail for 14 days, or should you stay in jail for 6 months?
14 days.
And why is that?
Because I feel like I can do right, and I feel like for the past 4 years, I've been out of trouble, and then I made one bad decision for me to stay in jail for 6 months. I feel like I can do right. If not, I guess I have to stay here for 6 months.
Okay. And who are you going to live with?
My grandmother's just my parent and guardian. My mom's been deceased for 5 years.
That doesn't answer my question. Who are you going to be living with?
My parent guardian, which is my grandmother.
So you and your grandmother share the same house?
Yes, ma'am.
Okay. So when the state asks for 12 months to serve, as the Fulton County Jail gives a 2-for-1 ratio, that would be requiring you to serve at least 180 days at the Fulton County Jail. The court is read the warrant, and then the behavior from that one bad decision was not just a simple display. It was a full-fledged nudity in front of a daycare center where you have children involved. This was a bad decision on so many levels. I do believe that as an individual, Mr. Stevens, you do require some medical attention. But at the same time, I cannot mitigate the nature of the offense that's been alleged. I'm going to require you to do 12 months to serve 180 days. I mean, to serve 180 days, well, to serve 12 months, where you will be actually serving 180 days, given credit for 14 days that you've already served at jail. Which, according to my math, he has 96 more days, 92 more days. Would that be correct, Mr. McLean?
If your honor gives him 12 months to serve, that he would have to go for the rest of the 6 months. If your honor gives him 6 months to serve, I'm a little confused. If your honor gives him 6 months to serve, he would go to the 90-day mark, and he would reach that 90-day mark in about 2.5 months.
No, it would have to be 12 months to serve. So y'all need to let me know how, I know he'll have to serve at least 180 days. Given credit for 28 days.
That's about 170, that's about 6 months away for him. That's about 170 days instead of 180.
Mhm. Is that something you want to do, Mr. Stevens, or do you want to go to trial? You can talk to your attorney at this time. Go ahead and ask him if you need advice.
No, the trial, if he lost, that's worse than Captain Q anyway. So you probably ought to step back and think about it a bit.
If we can mute courtroom too, so we don't hear the conversation.
Oh, that's a good point. Let's mute it. Oh, mute again, please. Mute again. Okay. Mr. McLean, you can unmute when you're ready to address the court.
Judge,
Mm.
quickly, can we go over?
All right. Your honor, I would like to ask to withdraw his plea and go the competency route. I feel like that would be the best solution at this time.
All right, you'll be submitting a competency, the evaluation order.
Yes, your honor.
All right. So in position plus 29, we're going to get an evaluation order. The bond remains the same. And the case is going to be reset to the competency calendar. The next competency date would be March.
Put out a letter for him, probably like the 16th.
March 16th is the most optimistic date I can place him pending the evaluation.
That sounds reasonable. March 16th.
All right. If Dr. Clarity is able to identify a inpatient program for her grandson, the court is always open to considering release on conditions.
Okay, I tried to take him to the behavior. There's a, it's like outpatient, but it's they have an inpatient bed.
Nope. It's got to be an inpatient program.
No, they do have both, and
right.
that's where I tried to take him, but he was telling them he's okay, but it's right over there by Southern Regional Hospital.
You need to get in touch with Mr. McLean and the Public Defender's Office and identify the program and so that they can bring it in the form of a motion to the court.
So is his number the same number I called, the 404-612-2392?
No, Mr. McLean will,
I'll call you because I've got your number.
All right, thank you. I appreciate it.
You bet.
thank you. All right, that concludes the calendar. Did anybody want me to go over the calendar again or,
I'm good, but I can only speak for me.
We
Mr.
have it, Your
Dotis,
Honor.
any questions about the calendar?
No, Your Honor, I took good notes. Thank you.
Mr. McLean, you're going to rely on Mr. Dotis's notes?
I shall rely upon his notes very much.
All right. Best of luck, folks. I will see some of you at 2:00. Thank you.
Thank you, Your Honor. See you next time.
Thank you.
Yes, sir.
Bye-bye.
Thank you.
Everyone have a good one. Thank you.